Ms. Kretschmann, please unmute yourself.
Can you hear me now?
Hello, hello.
Barbara Kretschmann.
Okay, you need to turn on your camera too,
I did.
please. This is 26RO00644. This is a ticket that was issued on the 3rd of February.
This is fun. It's short. Alyssa sent this to me. It's short, but Grandma thinks she's going to tangle with the Chisnator. It ends exactly how you'd guess.
February, about 6:42 in the evening, in the area of Royal Oak near Main Street and Willis Streets. You were cited for operating a vehicle while using a handheld electronic device. You can admit responsibility, you can deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
The third, please.
Are you admitting responsibility with an explanation?
Yes, that's correct.
And what is your explanation, please?
My explanation, it was a hideous snowstorm. I picked up I believe when the officer stopped me, he stopped me and told me that I was on a sidewalk. There was a hideous snowstorm. I was trying to turn into a parking lot at a restaurant to which I was going. The way park.
I only have one question. I won't do it to her. I have a different question this time. Was there a hideous snowstorm?
Parking is in the way street parking is in Royal Oak. It's very difficult to see where the parking is and where the curb is. And I was trying to turn in. I wasn't 100% sure. I picked up my phone for literally a half a second, and I was naive enough to say that I had to see where I was going and looked at the phone. And he gave me a ticket. There was not one soul nearby. The weather was hideous, and I believe that the officer took advantage of the situation.
What drew his attention to your vehicle, ma'am, as I look at the notes on the ticket, was the fact that you weren't able to maintain your lane as you were driving on Main Street. Then you drove onto the sidewalk in front of Beppe.
I did not drive onto a sidewalk, sir.
Well, you're
I
not
was turning in.
I'll bet you anything she did. That driving on the sidewalks will draw the cops every time.
I know. I was not. He told me after that I was not cited for that. I would not drive onto a sidewalk. I have pictures. I went back and took pictures because I was so disturbed about the situation.
But when it's in your hand and you're operating the car, that's against the law.
It was, if I had not picked it up, I would not have known where I was going.
Ma'am, I didn't write the law. You didn't write the law. We both have to comply with it. You didn't comply with the law. You're explaining why you didn't.
I don't believe that's why I got a ticket. And I don't believe that's why I got a ticket. I believe I got a ticket because the officer said that I was on the sidewalk, which was not so. And I have pictures to say, I have pictures to back that up.
That you took it later on.
Right after I got out of, right after I turned into the parking lot.
Well, how did you get in the parking lot without crossing the sidewalk?
I believe what he's trying to say here. I believe what he's trying to say is this.
Ma'am, are you a whore?
Bad Mike, I can't behave. Not even for Grandma.
I wasn't on the sidewalk. I was on a curb that was going into the parking lot.
You're on a curb?
I was on a curb because of the way that the parking spots are structured in Royal Oak. You can't, there was so much snow you could not see. You absolutely was impossible to see where you were going because of the snow. And I was trying to be safe to ensure that nothing was going to happen.
Ma'am, if it's impossible to see, how can you possibly be safe if you're moving?
This is going to be a word game. What can I do?
What you can do is pay the ticket. You
I
pay
did.
the bond, and the bond will be a.
Oh no, you didn't. You didn't just accuse the Chisnator of playing a word game with you, did you? Oh, Grandma, that was not the way to go.
Applied to the fine. You are
I would
responsible. You
not-
rightly
I want-
admit responsibility. I'm going to apply the bond. You don't need to pay more money. And that closes the file. There's no points for this.
But it's on my record.
Yeah.
It sure is.
Is
What
the
good is a
officer,
record if it doesn't reflect what happened?
is the officer there in the courtroom?
Ma'am, you've admitted to, first of all, to answer your question, yes, he's not in the courtroom. He's online just like you are. But secondly, you admitted responsibility and you did, and you rightly admitted responsibility. It happened. It's going to be on the record.
Let's finish this then.
We are finished.
Oh wait, I have to go back just for that expression. Where is it? I should have let it go out longer. I like that she says, "Let's finish this." He already ruled. It's over. But the expression afterwards, he's so satisfied and should be. He deserves to be.
But secondly, you admitted responsibility and you did, and you rightly admitted responsibility. It happened. It's going to be on the record.
Let's finish this then.
We are finished.
There we go. We are finished. Take that, B. All right, I can carry on now.
It's just 9:30. It's supposed to be 12. I gotta check in with y'all. So it's at noon. Y'all sit up here and just let it on. Why y'all do stuff like that? Y'all sit up here do unnecessary work. Then when they come ask me what's my name, when we come in here, that's the first thing y'all supposed to do. Come ask people their name last meeting. When they come into y'all courtroom. But y'all know what y'all done. I ain't no apologize, man. Y'all know what y'all do.
Would you like to see?
I can stay here and talk to you. I'll sit right here. I don't need to go see. So they're trying to wake me up, like, what's my name? That's our job to do when we come in here. And then when we act like that, look outside when y'all get it, look how y'all got the sarty face. When people act like that in y'all face like that, look how disrespectful y'all are. But you can't accept it. When we bring it like that to y'all, can y'all? No, y'all cannot. Sit up here asking my name when that's your job in the beginning. You don't have to say sorry right now because you don't say sorry in the war when you defend yourself. So you don't have to say sorry. Say sorry going to war. It's hard defending yourself. Apologize, man. How you gonna apologize to somebody when you staring at them all day in the courtroom but when it come at them last minute? Go down. I'm sorry.
Please have your seats, everyone. All right. Now we're back. And back to you, Attorney Viejas.
Honor, at the top of the 9:30 calendar, Mr. Ronald Bailey is the first matter.
All right. Donald Bailey.
I'm here, Your Honor.
All right.
I just don't want to sit there, but I'm here, Your Honor.
We will need you to come up, sit here, just because this is where the mic is to pick you up for the record.
I have a decent allowance for some sort of course, can you understand it here?
Your Honor, if it helps, this one is a dismissal.
Oh,
So
okay. Well, no need for you even to get on the record, it sounds like. All right. Go ahead, Attorney Facio.
Okay, he gets bailed out because the prosecutor was going to dismiss. It's disappointing. Zach's note to me was funny. This was brought to you by Zach. This particular clip is his fault. Most of this is his fault.
it moves to dismiss without prejudice.
All right.
But now he's going to walk out of there because this case got dismissed for reasons absolutely unrelated and think that he's intimidated everyone with his nonsense. He's going to be emboldened for the next trip to court. which won't be long. Don't worry with that attitude.
All right, Mr. Bailey, to that theft in the third degree charge, state is moving, or City of Tumwater looks like is moved to dismiss. So what I'm doing is filling out judgment and sentence form showing that that charge is dismissed. Welcome. All right, so we're going to print out a copy. There's nothing you need to do with this document. If you'd like to keep it for your records, though, I advise you do that, but you don't have to file it anywhere or anything like that. The case is just dismissed. All right. Do you have any questions about that?
I don't. Not at all.
At least he had the good sense to shut up at that point.
Exactly. Ready to go. Back to you, Attorney Viejas.
Your Honor, second on that calendar, Mr. Fernando Cruz Solis is joining us.
All right. Even, can you hear me?
Yes, sir, I can hear you.
All right, I'm able to hear you as well.
This is from Zach too. What an a-hole thing to put on your to put on your Zoom. I don't know what happens, but it's funny as hell.
The prosecutor is going to be here in just a minute. He was down here actually in the courtroom. He's going up, so Riley, he'll be logging in.
Okay.
I'm sorry, I said Riley, Kylie.
It's okay. I responded anyway.
Even, is your mother there?
No, she is not here. She's at work right now.
All right. Mr. Fighter, Avon said his mother is not here. He doesn't have an attorney. I can't, especially given the recommendation about the revocation of the consent calendar status, I really can't go ahead unless is there a way possibly to get his mother on the phone?
She emailed me this morning asking for the Zoom information, so I am unsure why she's not on. I can give her a call.
Okay, if you wouldn't mind.
Yes.
Riley, I don't know if you can hear me, but I have her, I believe. She just popped in.
Okay, I did not call her.
Okay, good, wonderful. Okay, Ms. Kreitner, can you hear me?
Yes, sir, I can.
All right, we are ready to go. Just so the rest of you folks know, Avon and his mom do as well, but I did have a hearing with them yesterday, just on some fines and costs that Avon hadn't paid on a cigarette smoking ticket. Avon can fill you in a bit if you desire, Mr. Fighter, as to what happened there. All right, Mr. Fighter, what brings this matter before the court?
Your Honor, I had issued this show cause approximately a month ago. Unfortunately, Mother Nature was not in our best interest, and the court was closed on the day we were supposed to have the show cause. So some of these dates are going to sound a little outdated, but just bear with me. So on January 13th, 2026, Avon's consent calendar status was extended to allow him to complete a 12-week substance abuse program with Jeanette Sayre, as Avon has struggled with substance use since coming to probation. It's been Avon's hardest craving for him, marijuana, nicotine. It's been super hard for him. Avon continues to struggle with these substance abuse cravings, and he expressed that he wanted to stop using marijuana completely. Multiple appointments were scheduled from January to the middle of March, and there has been more since, but when I had issued the show cause, from January to about the middle of March, to help Avon combat these struggles, combat these cravings. On February 19th, 2026, I had received a phone call from Ms. Sayre. She reported that Avon was requesting a telehealth appointment, as he had to watch his cousins for the night, and his mom and his aunt had already left the house. I had received a phone call from Avon stating the same. I had stated that I needed Avon's mother to confirm this appointment, or to confirm this arrangement, as this is a court-ordered substance abuse program. moments later, I received an email from, and I say Amanda in quotations, as it has titled Avon's Counseling, which read, "Riley, it's Amanda. I'm busy at the moment. I was letting you know Avon is watching his little cousins today for his aunt. He mentioned that you needed details about what was going on today so he could do over the phone counseling." Amanda later confirmed that she did not write that email. Avon did from her email. I don't know why or how, but it sounds like Avon is signed into her email, and he had emailed me posing as Amanda. Avon and Miss Sarah and Amanda did a three-way call, and it was reported to myself that Avon was yelling at Amanda during the entire phone call, and he was mad at Amanda for not lying for him to myself and Miss Sarah. He stated that he wanted to stay home and play video games, and it was later communicated that he did eventually make it to counseling. He arrived approximately 15 minutes late. And to give it in perspective, Avon lives probably like a 5-minute walk from Miss Sarah's office. Maybe it's a 7-minute walk. And that's why Avon is scheduled at the times that he is scheduled to accommodate his walking. On March 5th, 2026, I had received an email from Avon stating, "Hey, Riley, I forgot I had therapy today and I'm at a buddy's house right now out in Waters, and his dad just left to go to the store and is not going to be back for another hour. Is there any way I could do it tomorrow?" Then I received a call from Avon to confirm this I called Avon because his email box was full. I asked him if he had spoke to Miss Sarah about it, and he stated that Miss Sarah said that he could be squeezed in the following day. Then it was reported that he did not go to counseling the following day. He refused to go. Miss Sarah did contact Avon. It seems like a couple times. I believe they were having a texting conversation throughout the day, and then Avon just refused to respond. What it's called is he left her on read, which means it shows that he read the message. He just did not respond. On March 10th, 2026, I called Avon about the email he had sent this morning, and I stated that a conversation would be held.
Oh, this kid's playing a video game right now. I have zeroed out.
Due to his missed counseling appointments. He asked if we could have a conversation sooner rather than later, and I agreed, and we were supposed to have a conversation later that day. Avon did not call as instructed and did not call me for that following week. So my recommendations are that Avon's consent calendar status be revoked and Avon be placed on formal calendar probation. Avon complete a sincere apology letter to Miss Sarah and turn it into the probation department by April 30th, 2026. And Avon complete a sincere apology letter to his mother and turn it into the probation department by April 30th, 2026.
All right, thank you. Avon, did you hear what Ms. DeFighter said?
Yes, sir.
I'm going to go through the rights that you have. You have the right to an attorney. I know you've given up that right in the past, but if you wanted to have one for this hearing, one would be appointed for you. In addition to the right to a hearing, the right to an attorney, you do have the right to a hearing where probation would have to show by a preponderance of the evidence that was what Ms. DeFighter said was true. If probation could not do that, the matter would be dismissed. At that hearing, you'd have the right to have you or your attorney ask questions of witnesses against you, and you'd have the right to have the court order your own witnesses to be present. Do you understand your rights?
Yes, sir.
All right. As to an attorney, do you wish to have one, or do you want to continue to proceed without one?
Continue to proceed without.
Oh, that's funny. All right. It's not as fun thinking that he did it, but still it's funny. Thank you.
And Ms. Kreitner, do you agree with your son's decision to go ahead without an attorney?
That's fine.
All right. Avon, if you could raise your right hand, please. Do you promise to tell me the truth, the whole truth, and nothing but the truth, so help you God?
I promise to tell you the truth, nothing but the truth, and the whole truth.
All right. You can put your hand down.
Okay, yeah.
Once again, did you hear what Ms. DeFighter said?
Yes, sir.
Were the things that she said true?
Yes.
All right. Is there anything else you want to tell me?
No, sir.
All right. I will find you responsible for the show cause violation. We've heard the recommendations from Ms. DeFighter. Mr. Fortier, do you have any comments on those recommendations? You're muted, sir.
Sorry, not on the recommendation specifically. I think it's I hope he realizes how incredibly disrespectful it is to try to circumvent his responsibilities to the court and to his counselors and to his probation officer. He's got some growing up to do. He's going to get thrust into the real world here pretty soon, and he's going to realize real quick that kind of behavior is unacceptable in an environment basically of daily life. So hopefully he uses this as a teaching moment more of than considers this being, obviously there's an aspect of punishment here, but hopefully he uses it as a teaching moment so that he kind of understands his behavior and how he can make himself a little more responsible.
Okay, thank you. Ms. Kreitner, is there anything you wanted to say?
I'm just lost for words. Like, I've been telling this kid to stop doing stuff. He could have been off probation a long, long time ago. And I'm talking to a wall sometimes. So, like I tell him, every action has a reaction. So now this is what he has to do. Like,
Right. That's a good point. Mr. Fighter, if things had gone well from the start, when would he have been off probation? Approximately.
He would have been off probation, I believe it was this month on April 6th. I do know we were looking at letting him off early back in November. Then he had a vaping incident at school. And so we looked at December and then January, and now we're here.
So the earliest though that it would have been was, had things gone well right from the start, was back in December, you think?
Yes, I do remember when his grades were improving and we were looking at potentially getting him off. His first target date was in December, but legally, due to the new JJ legislation change, it would have been April 6th. He would have had to be off probation or extended or moved out.
All right, and now we're looking at when?
I cannot give you that honest answer. I would have to do that for his dispositional report, and I need to take a lot of things into consideration. I do know that he has been going to counseling now since this show cause has been issued, which is phenomenal. That's great. I want to talk to Miss Sarah and see how many appointments he really is behind, how many appointments is, what's his end date kind of look like for his substance abuse program, because my deadline needs to align with that as well.
Sure. Okay. All right. Thank you.
Also,
Even,
Your Honor, can I add one more thing? Before we end today, if you are adopting my recommendations, he does need to be adjudicated on his original charge.
Okay. All right. Thank you. Even, is there anything you wanted to say?
No, sir.
Well, I will find you responsible for the show cause violation. Obviously, the admission was there. And I am going to adopt the recommendation that includes removing you from the consent calendar. Going back to the original petition that was filed, that charged incorrigibility. Do you remember the initial petition filed back in June of last year?
No, sir.
All right. Basically, it charged incorrigibility, which is basically stating that you repeatedly disobeyed the commands of your parents or the commands of the school. And this would include possessing vape pens, skipping class, argumentative and disrespectful behavior with administration, and attempting to evade school suspensions. Do you remember us talking about those?
Yes, sir.
Were those things true?
Yes, sir.
All right, I will accept the admission, placing you on the formal calendar. I know Mr. Fighter will have to schedule a disposition on this, but I will adopt the admission or the recommendations that you set out. I want to echo what Mr. Fortier said. Avon, how old are you now?
17. I'm about to be 18 in July.
All right, what you did, your mom's not going to lie for you. She made that clear yesterday when we had a hearing. She made it clear today, and that's the right thing. You don't want anyone to lie for you. You are old enough. You're really a man now. You got to act like one. You do that to a boss and you don't just get put on the formal calendar, you get fired. I mean, you got to show up for work when your job tells you to be there. That's just a requirement. Have you had a job yet, Avon?
Yes, sir.
Where have you worked?
Domino's and Burger King.
Okay, are you working there now?
No, sir. I'm currently trying to start a job at Dollar General.
Okay. Do you know when that job starts?
I do not. I just turned in a hiring packet that I was waiting for to start the job,
Okay.
so I have to wait for my manager to text me about it.
All right. And they will give you some days and hours you're supposed to be there, right?
Yes, sir.
Do you plan to be there when you're supposed to be there?
Yes, sir.
Okay. You need to do that with Miss Sayer, and it sounds like you probably are now. It's maybe a lesson you didn't want to learn, but I hope you have. You cannot, you're lying basically to a representative of the court when you're lying to Ms. Sayer. You're approaching something where you could have more significant consequences. You're now on the formal calendar. If something like this happened again, I'd be very tempted to send you away to detention. You can't do that. You put your mom in a real bad position, and then to be disrespectful, according to Ms. DeFighter's report, that while you and Ms. Sayer and your mom are on the phone, you're yelling at your mom. You just don't do that. Okay?
Okay. Yes, sir.
And everyone would tell me that and give me that same answer. The proof will be in the pudding. Let's see you do it. I expect you to change. Like I told you yesterday, your mom loves you. No question about it. And that doesn't mean she's going to let you do anything you want to do. Love is showing you, there's consequences for actions. Time to turn over a new leaf, to become the new Avon. You can do it. There's more to life than video games. Okay. Ms. DeFighter, anything else that you need at this point?
No, Your Honor. Is disposition just going to be set in 2 weeks?
That's, for a disposition, you mean?
Yes.
Yes, that would be appropriate.
Thank you.
Okay. Very good. Thank you. That does conclude this hearing. Thank you very much.
All right. Are we ready for Mr. Rayshawn Schaffner? And I will start announcing his cases. I believe there are 11.
He's also got one, he's number 56.
He's also listed as well.
He's also number 33.
Yes. So I will call out his cases. He's got, here's Mr. Schaffner now. We've got 21 CF 2364, 21 CF 2399, 21 CF 2362. That's the one that's number 33 on the docket. 21 CF 3297, 21 CF 3299, 22 CF 340, 23 CF 1155, 23 CF 1205, 24 CF 2048, 24 CF 2049, and then there's one more that I had a question about. It's 23 CF 1156. It's not on our docket. I believe the state announced a null pros in that case previously, but the case is still open in the system, so I just wanted to confirm on 23 CF 1156.
Hold on one moment, Your Honor.
Sure. Good morning. And I have Mr. Harper standby counsel present. Mr. Schaffner is pro se on all of his cases that I named out.
Your Honor, the state did announce a no pros on that case due to it not being filed on in a timely fashion.
Okay, so 23 CF 1156, it's not on our docket, but it's still open, but it should be closed. All right. So, all right, where do we stand, Mr. Schaffner? Are you ready to proceed?
I'm pretty, I filed 2 motions before, there was like a couple weeks ago.
Okay.
I'll be filing more paperwork within the next couple weeks.
Her review of the motions is awesome.
Okay, so the thing that you filed called reset bond hearing, I have a copy of it. I just haven't had a chance to do an order on it. Sir, it's legally insufficient. There's nothing I can do on this. It doesn't, you've just, looks like you've copied something out of a book that doesn't make sense. So,
Sir, it doesn't make sense. That's as far as I'm going to go with my analysis on this.
Reset bond doesn't make sense.
this does not make sense. It's like you copied some headings out of a book. It doesn't, this is legally insufficient, sir. So, I just haven't had a chance to enter an order stating that. I don't know what the other motion was.
Do you know what reset bond means?
I know very well what reset bond means. I also know what a legally sufficient motion looks like, and this is not it. So it's stricken as legally insufficient.
How is it?
Sir,
Can you justify that, please?
I don't need to
I've seen a few legally sufficient motions in my day, and this is not one of them.
justify it, sir. It's legally insufficient. It doesn't make any sense. I'm questioning your ability to, or your competence to represent yourself. How do you want to proceed?
Can the government,
How do you want to proceed? Are you ready for trial?
Trial has nothing to do with it.
That's my question. Today is
If you would've
plea,
looked at my
trial, or
other paperwork,
continue.
Did you look at my other paperwork?
Many times, Mr. Schaffner. Where's the state stand on Mr.
Your Honor,
Schaffner's cases?
Mr. Schaffner did not file a demand for discovery. The state has all of the discovery today with the USB drive. I did speak with court security just to see how the jail would like us to have that given to Mr. Schaffner.
So we were asked not to transport the documents from the jail. If it's possible for Mr. Harper to get them to him, I don't know what their arrangement is as far as that goes.
Or the state can get it over to the jail.
Could you use a courier to get it to the jail to
The
Mr.
state could do
Schaffner?
that, Your Honor, yes.
The state has all of your discovery copied. They have a USB drive. Did I understand that right, Ms. Giardina? A USB drive?
Yes, there's a
as well?
USB drive and paper
Okay.
files for each case.
So all of your discovery.
Can y'all put my motions on some type of projector so the court can see it?
Do what now?
Can I see my motions on open court, please?
Sir, I don't have time for that today with this massive docket. This is not a motion day. So it's plea, trial, or continue. The state has your discovery. They're going to deliver it to the jail along with a flash drive that you can look at the jail. So that should be there soon. So you can look at the discovery in all of your cases.
This guy is seriously so stupid. He blocked and pasted random crap into a document, gave it to the judge, and now is actually surprised it didn't work. Just random characters. I don't even know if it's in English.
Is the state ready to proceed? Which case do you wish to try first?
Your Honor, the state can go on 21 CF 3297 or 21 CF 3299.
Okay, and would you be ready this cycle or when?
Mr. Schaffner doesn't have the discovery, and he's got quite a few cases to go through, plus body-worn camera. The state would just like to give him the opportunity to review that before we go to trial.
Your Honor, I understand that I'm standby counsel, but if it's possible, the state has conveyed to me an amended offer. I'd like the opportunity to speak with Mr. Schaffner, hopefully this weekend, if we can bring him back for docket day. I think it's closer in line to what he expressed to me previously that he'd be willing to accept. I just need to have a meeting with him.
Okay. Mr. Schaffner, you heard what Mr. Harper says. He wants to meet with you because there's a new offer. Will you be willing to meet with him if he comes to see you at the jail this weekend?
Yes,
so he can
ma'am.
talk to you about it?
Yes, ma'am.
Okay, good. Thank you. So,
Was one of the motions to discuss some type of agreement also?
I don't know.
Wasn't that? I'm pretty sure that was one of
To discuss with who?
To discuss an agreement
With
the state.
the state? Well, see,
I put
that's one of the
I put
disadvantages
the
of
rule
of representing
procedure.
yourself. They can't just communicate with you at the jail. All the communication has to be here in open court or paperwork that they send.
The state can put
Yeah, where does he think this mythical meeting with the state's going to occur? They're going to go out for sushi or something? He's incarcerated. That's why you have an attorney, dummy.
On the record, the offer that
Go
it's
ahead.
conveying, it would be 7 years DOC, and that would come with amending charges and also dismissing certain cases. Mr. Harper has the score sheet of the updated charges that would be amended to if Mr. Schaffner were in agreement with 7 years, Department of Corrections.
Okay, so I'm sure Mr. Harper will come talk to you about all of that and all the details of it this weekend. All right, so please meet with him so you can at least hear what the proposal is, okay?
And just for the record, that includes credit for time served, that
Okay.
since he's been in since I believe 2021.
Yeah, I'm aware you have a lot of credit, sir. So, but the state can't talk to you while you're at the jail. Do you understand that? I mean, they can't come to the jail and meet with you. That's one of the disadvantages of representing yourself, that you have limited access to the state. You can only talk to them here in court in this type of setting. Do you understand that?
Yeah.
Okay.
Well, here are your options once you get married. You either get divorced, which is by far the best option, if you think that's good, or somebody dies. Those are your two outs.
So would you like me to bring you back on Monday? That'll give you time to talk to Mr. Harper about the deal that they're offering?
Today's Wednesday.
Yeah, that's April 20th, this coming Monday. It's not a motion day. But do you want to come back
Y'all
on?
want to do it that early, or could we do it in a couple months? Or we can do it on Monday. Y'all can bring it back on Monday.
All right.
Your Honor, the state, I'm so sorry. The state provided Mr. Harper with the paper discovery and the USB, since Mr. Harper is going to go see Mr. Schaffner at the jail
Okay.
over the weekend.
So Mr. Harper is going to bring all of your discovery and the USB drive so you can see all of that. Okay, he's going to give it to you. It's from the state, but rather than the state have to take it to the jail, Mr. Harper is going to bring it with him when he comes. Okay? So April 20th, docket day at 9 o'clock in all of Mr. Schaffner's cases. And please, Mr. Schaffner, when Mr. Harper comes, please meet with him so he can give you all those papers and he can explain to you whatever the offer is. They were talking about reducing some charges and things. So please meet with him when he comes, all right?
All right.
Thank you. We'll see you Monday.
I let that go for a little bit just for the satisfying clink of the chains.
All right, let's go off the record for a moment. This is the disqualification case?
Yes.
Okay. Is the defendant here?
Yes. Is that Kevin here, Judge?
Yes.
Yes, he's here.
Okay, so. All right, so let's go on the record in the matter of the City of Lincoln Park versus Jason Cavender. Thank you. 25th District Court case number 25L3452 and 25L0578 and 26L0578, 26L0577. There may be a fourth case, 25L0796. I'm not sure. That's on this other case here. And so, counsel or appearance for the people, please.
Zelenak on behalf of the City of Lincoln Park. Good morning, Your Honor.
Good morning. And appearance, counsel for the defense.
Good morning, Judge. Mazin Gates up here on behalf of Mr. Cavender. The stands here to my left, my right, and state your name, sir.
Jason Cavender.
Okay, counsel, you appointed or retained?
I'm appointed.
Okay. I didn't have that information. Can you spell your last name, counsel?
Ghaith.
And your P number.
73845.
Okay, so I need to get up to speed here for just a short bit. This is a matter that's been reassigned to this court, because I seem to be things all disqualified cases, from the 25th District Court. And I'm showing a charge of disorderly conduct, tampering with, or malicious destruction of property on the 26L0577 case, date of offense January 30th of 26. Then we have on the 25L3452, the 260578 case, we have what appears to be a pretrial. No, okay, these are all in the wrong files here. And that date of offense is also January 30th.
I'm sorry, Judge, what was the case number for the case that you were just referring to?
26L0577 was the first one. 26L0578, stalking, is the other matter. Then, so this appears to also be an arraignment pretrial. Then there's 25L3452. The date of this offense appears to be November 21st of 25, disorderly conduct. And originally Judge Clifton was the judge. Then this was already set for a bench trial for May 1st. However, this got reassigned over here. So let's handle the arraignment on the two matters from January 1st. But I'm not sure why all these other notices for all these cases are in one file. I don't know about that. Oh, because there's the victim's a court employee. That's why it was disqualified. All right, so let's handle the arraignment on the two new matters first, please. And counsel, I'm going to give this back to you to make sure that you have the court, the case numbers on there, please. Dave, if you can hand this back to the attorney so he can put the case numbers on there. Counsel, I ask the arraignment on both matters.
Judge, we'll stand in waiver.
Okay, the court will waive the formal reading. Enter plea of not guilty for purposes of the arraignment. And then ask to the pretrial.
Your Honor, on behalf of the people, may I address the as to the pretrial and in this matter?
First, let's address as to the pretrial, please.
Counsel has just spoken with his client today for the first time, so he's not in a position, I believe, absent receipt of discovery. He was reassigned. They removed the counsel from Lincoln Park and appointed him to represent. We spoke on his way in that he's been unable to get a hold of his client because the number in the file is the number for nursing home. He has not made contact. He would tell you that, so I'm telling you ahead of time. So although I'm prepared to welcome a plea of no contest to the charge, there's no other offer on the table today, Your Honor. We take whatever court decides beyond it. I'm sure counsel's not going to accept it, not having
Can we make a copy of, actually, there should be three. There should be three case numbers on here, counsel.
Are we arraigning on the pretrial then?
No, it's the other two cases.
Right, I thought it was, my apologies, Judge. I thought you only just wanted for the arraignment on the.
Well, no, all the case numbers should be on here, so if you can make two copies, please. So we need to adjourn this for discovery then.
Correct, Judge. And the number, like Mr. Zalek said, the number that was provided in the file was not accurate. I confirmed that with Mr. Cavender this morning. We've been trying to reach out to him for the last week or so. We've been unable to. So this is the first day that I've actually spoken to Mr. Cavender. We do need some discovery, as well as Mr. Cavender does have some additional material that he'd like to consider. I'd like, if it is relevant, I'd love to bring it to the attention of Mr. Zalek as well. Perhaps that would help us reaching a resolution.
And so, counsel, how long are you seeking an adjournment for discovery purposes?
Would the court give us 4 weeks, Jeff?
Well, given that one matter has been pending for quite a while, and that the other matters have been pending since January, I'm not inclined to go out 4 weeks.
What available days does the court have?
Tuesdays are good days, how I speak on behalf of people, but 11 o'clock's probably a better time. For some reason, if the defendant continues with appointed counsel, their mornings are pushed on Tuesdays also. And I know the court has a busy docket on Tuesday. So if you did something at 11, I could come any Tuesday.
Well, fortunately for counsel, you're going to get your 4 weeks because 2 weeks, I'm in another court on a jury trial for yet another disqualification. I don't know why there's a magnet this way for that, apparently. The next week, the court's closed for election stuff, and that puts us at 4 weeks. So May 12th. May 12th?
That'll work for me at 11 o'clock, Your Honor. I know what I have that morning. So if 11 o'clock works for you, Your
Does
Honor.
that work for us? Yes.
And I know I like being here at 8:30, but I'll come at 11.
11 a.m. on all matters. And then as to, well, first, do you need a discovery order?
Yes.
Okay. There's one in the prosecutor's office. Did you grab one, Mr. Zelnick?
We'll get one and send it back in, but
Okay. And as to bond,
may I address on behalf of Your Honor?
yes, after I hear from Mr.
Oh, go ahead. I'm sorry.
No, that's okay.
Judge, obviously, we're asking for a personal bond in this matter. Mr. Cavender has appeared, to my knowledge, for all his other court dates. And obviously, he is eager to get this issue resolved. So I don't see that he would, I don't see that he would be missing any court dates, Judge. I don't know that he's a flight risk or a danger to the community, Judge. I would ask for a personal bond in this matter.
Okay. Well, I can tell you that it's likely that the May 1st bench trial is going to be off, just so you're aware, because that was what was scheduled on the 25 case.
Understood.
So, and I don't even see an ROA in here. Oh, here it is. It's right on. Mr. Cavender. Well, you did fail to appear January 22nd.
Yes, ma'am, and I didn't receive the paperwork from the city of Lincoln Park when I was supposed to come to that date.
The city of Lincoln Park or the 25th District Court? There's two different things.
25th District Court, madam. I've never missed any of my court dates on my, the appointed attorney.
Previous appointed counsel, Judge.
Made sure that I showed up to everything and I have done everything I'm supposed to do, madam.
Okay, I don't have the benefit, well, let's see here. The two of you are neighbors?
Yes, ma'am.
I seem to be a magnet for those cases also.
I think there's a sign on the roof of the courthouse next to the always open.
All right, Mr. Zelnick, as to, well, actually, Mr. Cavender, where do you work?
I'm unemployed, madam.
When's the last time you were employed, sir?
Probably 3 years ago.
How do you support yourself?
My wife has been paying for me.
Okay, and why haven't you been working, sir?
I have tried to put 155 applications on Indeed alone. I have not been in. I just did an interview yesterday. I never get called. My passive stuff, I can do any of the other stuff. I never get. I don't know what you're talking about. No one's hiring.
Well, lots of people are hiring.
I've done over probably 300 different job applications on the 3 different computer sites, and I don't know what to tell you now. Get any calls back. I do interviews, and then that's the end of it.
Okay, and are you currently out on bond in any other jurisdiction?
No, ma'am.
Are you on probation or parole anywhere?
No, ma'am.
All right, Mr. Zelnick?
Thank you. And Your Honor, I don't want to either punch down or punch up, but the defendant in this case has an apparent dispute that ran through even into the lobby of this courthouse today and uttering obscenities towards the victims in this case in the courthouse this morning and had to be instructed to be quiet by one of your court officers. It continued, or it started in the parking lot here today. They're next door neighbors. He's a renter. They've lived in the home they own for 37 years. One of the victims is a court officer in Lincoln Park. And the defendant, it's egregious if you were to read the substance of the allegation as to how two neighbors can't get along, but that it should continue. The things should happen that are alleged by the victim, female victim here in the case, and the male victim, and the damage to the property, and the disregard for the tones of civil society by the defendant. So he'd ask for an instruction that he not have any contact. I know you can't stop people from looking cross-eyed at someone, but beyond that, there's no reason to utter obscenities, to call them names. Similar to what was said in the allegations of the complaint in the halls of the court here today, in the parking lot, or in their neighborhood. They each own a 40-foot lot. He may not, but he lives there and he's been there for 10 years. The second issue that we're concerned about, and I don't want to offend the MIDC lawyers who do this as part of their living to supplement their income, but on the application for counsel, I was told at the court, he just listed 0 for everything, no assets. I know he owns a truck, a couple of jet skis. He grew plants in his house. It's hard for me to believe because I don't know any court officer who has 2 jet skis or a truck, which is a business truck, nor that they would turn down a job across the street at the gas station who's got a now hiring sign, or over at Starbucks, or over at Krispy Kreme. So I find that it's easier when you don't have any skin in the game to push the limits of the matter, reject plea bargains, set matters for trial. I think either this court or the Lincoln Park Court should reevaluate whether there's a true affidavit filed for financial purposes, to receive court-appointed counsel, to retain their own counsel, because this is truly a next-door neighbor dispute. And it seems just the next thing we probably could do is have Uber Eats here, maybe Uber drive the defendant to the court since he has no assets. And I'm not punching up or down. I just think it's grossly unfair to pick on a neighbor to do the allegations that are here and then come to court and say, I have nothing, you're going to pay for anything for me.
So, Mr. Cavender, you keep shaking your head.
Sir, this whole...
First, I'm not a sir.
Ma'am, I'm sorry. This whole dispute started with the homeowner.
Listen, I don't want to know about the whole dispute. We're not talking about that right now.
Okay.
Were there comments that were made by you this morning?
I didn't say anything to the man. He's always staring at me, trying to start a problem, madam. This is the way it's been.
Pause. This sounds eerily familiar to another set of neighbors that I have matters with from Riverview. So, if somebody's looking at you, sir, that's not an invitation to start something.
I understand it, ma'am.
Did you open your mouth and make any comments at all
I didn't make
in the vicinity of the victims?
No, ma'am.
Not at all.
No, ma'am. I didn't say anything to the man.
Mr. Zelmack, what is it that you're referencing?
What did he say? May I bring the victim forward, Your Honor?
Of course.
Of course. You're going to give your name, speak clearly.
My name is Dwayne Wilson.
All right. Can you please spell your first and last names?
D-U-A-N-E. Last name is Wilson, W-I-L-S-O-N.
Thank you. And what is it that Mr. Cavender, that you heard him say to you?
Well, I read his lips on the way in.
No, just say what you heard.
Today, I looked over at him and he said, "Fuck you, asshole."
He said it loudly, or he was moving?
He said it loud enough.
Please let me finish. Let me finish, please. Only one can be picked up on the recording at a time.
But that's what I said to you too.
Stay muted, Mr. Forbes. Did Mr. Cavender verbally say that to you, or did he look in your direction and did he mouth those words?
He looked at my direction and I heard him say those words.
And were you outside in the parking lot or inside the courthouse?
We were inside the courthouse.
And were you in the lobby?
We were right in where the chairs are, yes.
And so where was Mr. Cavender sitting?
Sitting in a row of seats in the back, and I walked towards the front.
In the back, meaning?
The back part of the lobby.
The one closest to the doors, the security area?
Yes.
Okay. And then you were in the front, closer to the courtroom doors?
Yes.
And at what point did you, so Mr. Cavender was there, he arrived first?
My wife and I were in the courthouse already, and then he came in a little while after.
Okay, so you were already sitting in the front row?
We were sitting in like the third row, and when I walked, we were going with Mr. Zelenak into the office.
Okay. And is that when you heard Mr. Cavender make that statement?
Yes.
Was his attorney here yet?
No, ma'am.
Okay. Mr. Cavender, did any of that occur?
No, ma'am. This is what I've dealt with the whole time.
No, listen, it's yes or no?
No, ma'am.
So none of that occurred?
No, ma'am.
This individual just completely made all of that up?
I was sitting there in the.
No, excuse me. So you're telling me that Mr. Wilson made the entire thing up just now?
I didn't say anything to him, madam.
Yes or no?
No.
Did he just make the entire thing up?
No, I guess.
Okay, so what is it you said to Mr. Wilson?
I mouthed coward to him. That's it.
Okay, well, he was to the back of you.
He was in front of me walking
I'm
into the
sorry.
next office.
Excuse me. He was in front of you. His back was to you.
No, he was looking directly at me, staring at me the entire time.
So he was walking backwards to the office?
He was walking across this way, staring at me like he always does.
Mr. Wilson, when you were on your way into the office, were you looking at Mr. Cavender, or were you looking at your attorney and following your attorney?
I was looking at him.
Why?
I didn't stare at him. I looked over at him.
Okay, for what purpose?
There was no exact reason.
There's not any reason to look at him. None. Because that seems to be what sets off Mr. Cavender to start running his mouth then. Mr. Cavender, because somebody looks at you is not an invitation for you to start saying derogatory statements to them. You're in a courthouse, not a playground, not a bar. Keep your comments to yourself. Keep your comments to yourself when you're at your house.
I didn't.
Don't write on chalk. Don't write with chalk on the sidewalk. Whatever thoughts you have of the Wilsons, keep it to yourself or your wife or whoever else is in your home, that you just quietly speak amongst yourselves and not loud enough that it can be heard outside the windows.
Yes.
Do I make myself clear?
Yes, ma'am.
Mr. Wilson,
Yes, ma'am.
you and your wife, when you are leaving your home, don't even look in the direction of the house of Mr. Cavender. There's no point. Clearly, the two of you don't get along, right? And there's zero benefit to looking in his direction or looking to see what he's up to or anything else. Is it frustrating? Sure. I'm sure you're both very frustrated. All of you very frustrated. But that's one thing you all have in common, at least. You're frustrated. So there's one common ground there. All right. So the court's going to, and Mr. Wilson, I will say that I am going to presume that one of your levels of frustration is statements made toward your wife, which I can appreciate your frustration with that. However, communicate with Mr. Zelenak if there's any violation of this court's order or any perceived violation of this court's order or something that you're frustrated with, because as the prosecuting attorney, he will have to know that information and then he can communicate with the defense attorney. Do not take it upon yourselves to communicate with Mr. Cavender. Do I make myself clear?
Yes, ma'am.
Mr. Cavender, do not touch property that doesn't belong to you at all.
It was on my property, ma'am. That's why I brought the landlord.
Do not touch anything that does not belong to you. If there is a property dispute, okay, how about you all bring for a surveyor and split the cost? How about that?
I have that. And also the reason I had to touch the property is because it was against my vehicle, ma'am. I couldn't get my vehicle out of the driveway. These stakes.
We're not talking about the facts of the case. I've made that clear. Do not touch property that doesn't belong to you. If you think it is on your property, take a photograph and send it to your attorney. And then your attorney can speak to Mr. Zelenak. Because we can't have any communication between the neighbors. That's not going to happen. And Mr. Cavender, you are going to have to also submit a copy of your income tax return, some assets or anything of that nature that you have, so we can determine if you are appropriately ordered to have an appointed attorney at public expense.
Judge, what day would you like that submitted?
That has to be submitted by April 17th. I don't accept just zeros filled in everywhere as appropriate. Do you own jet skis, sir?
Yes, ma'am.
Are there monthly payments on those?
35 years old.
Are they insured?
No, they're broken. They're both broken. They're worthless.
Okay, then indicate that specifically.
I did that on the paperwork, ma'am. I did. I wrote all that on my paperwork for the application for Lincoln Park when I got
Okay,
it.
I don't have a copy of that, so.
Well, I did, and that's not the truth of what he said.
Sir, as I was saying, I don't have a copy of that, so that's why I'm asking for you to submit that information.
If the court's got their own form as far as for consideration of appointed counsel, can we have one? I will have him fill it out and detail it, and then we'll also submit a copy of his income tax returns by Friday. So
We can do that. Bobby, can you just see about getting a copy of that form that we have? Please, thank you. Okay, so I'm going to order a $7,500 personal bond on each case with the bond conditions that this court set forth just a short moment ago regarding no assaultive, threatening, abusive, or intimidating behavior towards victim, not to enter the property. Do you have any firearms or any weapons, sir? I'm going to specify no verbal or non-verbal communication. That means any gestures, any mouthing of words or otherwise with either Mr. Wilson or Ms. Wilson. All right, so you can have a seat, sir. You're going to get paperwork to fill that out. You're also going to get a copy of the bond conditions. What I'm going to do is we're going to make 4 copies. That way each attorney has a copy, and then there's a copy for each of the files.
thank you, Your Honor.
Thank you.
Did you want me to fill that out here, or I thought my suggestion would be that he filled it out and find submit it along with the other.
That's fine, but he has to get a copy of that paperwork before he leaves.
Okay, and then can I email it to the court, Judge?
Yes, that's fine.
Thank you, Your Honor.
Thank you.
Calls number 41E2601683, Kay Clark versus Mohammed Hosseini Vanessa Plata and all occupants. I don't know if I said your name right. I apologize.
Close enough. Good morning.
Good morning. All right. How much is the monthly rent?
$1,800, Your Honor.
No subsidy?
No.
Okay. And what months are you seeking, please?
March and prorated April for a total of $2,209.49.
So did you pay last month or this month?
I've paid every month.
Okay. So do you have receipts for March and April?
I actually have the ledger printed from this morning from their website showing the $1,800 as well as the $35 as a resident benefits package. So it's $1,835 in total. And it does show that I have paid each month.
So you have a zero balance?
I do not have a zero balance. So what has happened is there was an incident in October where the garage door was damaged. In regard to the garage door being damaged, I notified Rhonda, who is a representative that handles the maintenance at Kay Clark. She said she'll speak with Kevin, which is the property owner and broker. And they'll get somebody out there to fix it. The following month, I see that $1,184 and some change is added to my rent. I send a letter outlining the tenant landlord laws, certified letter, specifically 92.162, to try to settle this matter out of court. I got no response back. I then noticed in December there was eviction fees with late fees attached to my December rent. I then made contact again to no avail. Moving forward, I saw in January the eviction fees were removed from the ledger. So I thought everything was settled, to come and find out when I paid my rent on time again for the following month, the eviction fees are there the late fees are there, and they've commingled the fees to be assigned to the garage door, then taking away from my rent, and then they attach 216 posting fees, and that's how they're accumulating that amount. But I have paid my rent on time each month.
See, it's a whole different thing when they actually pay the rent. I'm more than willing to listen to the defendants. If you're current on rent, you probably have an argument. Let's hear it.
Every month.
So what does it say in the lease about any kind of repairs?
It's the same thing as late fees. Anything that is paid, it goes to fees first. So it would be the application of funds. I personally spoke with him regarding the garage door after we sent the notice. I did talk to my broker, which is also the actual owner of the property. He is responsible for a garage door. He stated it was a neighbor or somebody that ran into it. That's something he would have to take up with his neighbor to pay for that. The owner's not going to pay for a damage that wasn't caused by him. So we were going to bring him to court prior when we saw that the rent wasn't paid in January, but we didn't end up filing. So we removed those fees. And since he hasn't paid, now we are brought him to court.
He paid, but
it went to the garage door first.
Yeah.
And so since everything wasn't paid in full, he received the late fees for not being paid in full.
Okay.
Your Honor, if I may, can I submit to you the letter that was sent outlining that it's not my responsibility to cover from a third party unless it was a tenant of my home or a guest of my home under the property code 92.052 and 92. Can I submit the letter to you so we could have resolved this? And mind you, Your Honor, I've been a resident there for over 15 years. I've lived in the property.
And who did this? What
I believe it was the next door neighbor. My daughter is a San Antonio police officer and she lives there. So she had worked the dog shift. I work from home. I hear a loud bang and I've had trouble with those neighbors. Quite honestly, they kind of keep to themselves somewhat. And I said, one of them left there drunk. It's early in the morning. They have parties all late at night. And
but why are they in your, I'm sorry to interrupt, but why are they going in your driveway?
That's a great question. And they literally will fill up the street. There's trailers on the street. They fill up the street, loud music. Police have been called there multiple times. So I hear a loud bang. I get up and I run out thinking they hit my daughter's car because that same neighbor hit another neighbor on the next street and damaged their vehicle and the police came and made a report. So I'm thinking they hit my daughter's car. She's asleep. I go look, my daughter's car is fine. I turn around to see the garage door dented and I see the vehicle driving off. And I'm like, I bet you he hit the damn garage door. And so I then immediately contact Rhonda, the maintenance department. I also notified Debbie as well. And in my report, I also, from the maintenance report, spell out exactly what happened. And I got no further notification in regards to, hey, this is your responsibility. Or, you know, I tried to work with them saying it was a third party. It's out of my control. I'm not responsible for the structure. That's why we pay premiums for insurance. When there's a loss, the insurance company is indemnified to take care of it.
Do you have insurance?
I do. Yes, ma'am.
So why didn't the insurance take care of it?
So
that would be his responsibility to contact his tenant's insurance.
So I did because she did inform me of that. I'll be honest with you. I'm an insurance agent.
Okay.
I write PNC lines.
Mm-hmm.
It is not an indemnification. I work for USA for us to cover a third party loss to a non-owned structure, unless it was caused by me, suddenly and accidental, someone I invited to the property, or someone that's on the lease of the property. So again, I sent that letter outlining it so we could.
Spoken like a freaking adjuster, but he's right. He's absolutely right. Everything he's saying makes sense.
Resolve it. I've been a tenant there for over 15 years. And I was met with no response. And here we are in court, but I have paid my rent every month on time.
Okay, where does it say in the lease that he's responsible for a third party that's not his guest, not on the lease? Where does it say that?
So there, I don't know what. Give me 1 second. I'm sorry.
And if I might add, Your Honor,
Because if you did sign it in the lease and it is in the lease, then the lease.
I went through the lease and I looked and I will say the documentation submitted to this court is a little misleading in terms of their own ledger. There's a scratch out that they submitted to the court for March on late fees.
I don't have their ledger.
I have it if you would like for me to present a copy to you. I do have it. And they submitted documentation to the court where the late fees were removed from March, this past March.
Or maybe I do. This is email. Let's see. These are just emails. It doesn't say any kind of monies. Let's see.
No, it's their property, not his. The damage was not caused by him. He doesn't have to pay it. Period. End of statement. If it was him or his guest or somebody else on the lease, then yes. But anybody else, no. I mean, that's just basic law.
Submit ledgers.
Yeah, I didn't think so. I just wanted to make sure. I didn't have it, but I don't have it.
Yes, ma'am. I can submit it. The court attached this actually for me when I got served.
You're saying basically he didn't pay for February or March, you're saying? That's what it says on the petition.
So he has made a payment since, he made a payment on April 1st, April 2nd, I apologize. Let me pull, you have that on page copy?
May I see what he has over there? That
So-
your ledger balance or your ledger?
This is what was submitted to the court and it was marked out.
He still owes $430.51, and then April in full. Because of the late fees.
Oh, I do have this. This was submitted to the court.
And it's marked out there. And as of this morning on their own ledger sheet, they do assign me that $216 fee. And that's where the commingling of the multiple line items are not adding up. I know what
I want to know what adds up to $2,209.49, because he's made his rent payment every month. This garage thing is a whole separate deal. If it's not in the lease, I'm not going to allow you to take it out of his money. I understand late fees. I understand if it's utility fees and all that, but a damage, you need to go through a different channel for that. I've been through this before with Kate Clark.
Tenants are responsible for their.
I want to see it.
Yeah.
I want to see it.
The landlord wouldn't be responsible for repairs that weren't made by.
He didn't. Okay, well, he didn't do it either. It's a third party, so.
if I might, Your Honor, we were in court prior to y'all having this beautiful facility here now on 410 under Judge Lopez. And it was a similar issue. And he also told the representative at that time, which was Dawn, that they cannot do that.
Yeah.
And they continue to do this. Now, there's like a $35 Beagle fee. I agree to that. I like the property. I take good care of it. Like I said, it's worth it to me. But I felt that this matter, especially with me sending this letter, where I'm willing to take care of it. I'm willing to, if it's my responsibility. After going through reading law, understanding insurance, it would be no difference if somebody came by and shot up the house and I have to repair the structure. It's a third part. It's out of my control.
I would determine how do we know he's not responsible for?
Or how do you know he is?
I made a good faith effort.
I'm going to allow y'all to take that out. You could sue him in a different manner, as y'all done before, because y'all were here.
Paperwork,
so I'm sorry, but I want to see that you've paid your rent every single month. Because then it should just be like the $1,100 instead of this $2,209.49.
Your Honor, may I approach to show you?
Absolutely. I need you to approach to show me, please.
Ramming really should be consensual.
I want to see that you've paid your rent every day, every time.
Starting in November, that's $1,800 to $35 rent paid.
Okay, and they're asking for
February and March.
February, March, yeah. February right here, February 1st with $35, the 1835. Okay. March. Thank you for being prepared.
Yes, ma'am.
1,800 with a $35.
This is what they currently have on my ledger.
How do y'all have $3,184.51? I have no idea how y'all came up with that.
That's with the garage door on there. So if you look back on.
So if you take off the $1,100, you're still at $2,000. Where'd you get the $2,000 from?
It's from late fees.
He's never been late.
Right, but when he makes a payment, that went to the garage door, so it's unpaid rent.
I'm not allowing,
I know what you're saying now, I understand that now.
Okay.
But, so I would have to do the adjustments, but he should be at his.
If I might interject, Your Honor, they're also assessing before you adjudicate and order me to pay their court fees. Over $700 in court fees is how they're getting to that 31.
Okay. He has been paying his rent on time, every single time. On the first, actually, not even on the second or the third, not even giving grace. He's paying it on the first. Y'all are charging him $216 every single month because of a garage door that you can't prove. You haven't proved in court that it's his responsibility. So this is a take nothing. And his needs to be adjusted to 0, and you can do whatever you need to do on that garage door. There's other ways, and you'll have to prove it in court that he is responsible for it, because in the lease, it does not prove it to me.
May I make one request, Your Honor?
Yes.
If I might, could you dismiss the case with prejudice?
Yes.
And if need be, can I file a countersuit with your court clerk for my?
You cannot file a countersuit under an eviction case.
Okay.
Dismiss with
Relax.
prejudice.
You won. You can file a separate suit, but you can't file a countersuit. And she's not your attorney. You were doing awesome. Just take your win and walk out. You should win. You did nice work.
I'm going to put in here, defendant paid
Well, let's not go too far.
on the 1st of every month with a $35 admin fee, I guess is what it is. I don't know what it is. Plaintiff has charged $216 per month late fee.
Want the ledger again, Your Honor, so you can reference it. There's multiple fees. I don't know if that's necessary.
I'm just
Okay.
per month for late fees. Defendant has charged defendant $1,100 plus for the garage door.
Garage door was $1,184. If you need to notate.
84. 1184. For garage door.
Also, Your Honor, if you need to notate, an eviction fee was assessed, part of that $3,184 for $288 and added to my rent. And then an admin fee for eviction process of $450.
For 450.
Yes, ma'am.
And what did you say also? One other thing? You said 450 and you said something else.
288 for, it's titled as eviction on their ledger sheet. So $288 even for eviction, and then $450 for admin fee for eviction process.
Okay, all this stuff, I don't know. This needs to all be taken off of his statement. I mean, he doesn't owe any of this stuff. This eviction shouldn't have even been filed against him. He pays on like clockwork on the 1st. This garage door needs to be taken to a different time, a different court, or not a different court, this court, but at a different time, not through eviction. It's not an eviction issue. And anyway, I'm putting that this is all illegal charges. You can't prove that he damaged the garage door. You haven't, and that's not here before me today. I'm doing eviction only, but still, in the lease, it shows if he damaged it, one of his guests or an occupant, or, and you can't prove any of those things.
I'm sure, Your Honor, it is in this lease. I just don't have it on me and I'm not.
Okay, well.
I understand what you're saying 100% and it will be corrected.
Okay, so it's a dismiss with prejudice. All right, thank y'all.
Court does call the cases of the people versus Shannon Kiesling.
John Brown appearing on behalf of Ms. Key, Your Honor.
Good morning, your name?
There's probably a second half to this that I didn't get, but I'm guessing she pleads. But this is fun. She just goes Karen.
Shannon Kiesling.
Your Honor, I'm moving to withdraw from representing Ms. Kiesling. There's been a breakdown of the relationship. I scheduled a meeting for Monday for her to come in and sign the plea forms and go over everything, and so that I could send over to the court for the no contest plea, the police reports. She tells me that she was here. I was here.
I have text messages and phone numbers.
And I have
Oh, good Lord. They can do that if it's in the lease. That policy would typically cover the interior and your belongings directly. All common areas and everything should be under their policy. The interior of the units on your policy. That's the way it is. Not a strange scenario at all.
witnesses in my office that verify my attendance in next door, that I was here in court. Based upon the miscommunication, there's a breakdown now. She's also.
Wait, it's gonna plead?
No.
I've been adjourned, I don't know how many times.
Oh, I know.
Things like happening. I mean, I've had.
That's why I set the meeting.
I've had my tether 9 months. I've been going a year. I've been doing AA. I'm doing everything.
What do you want to see happen, man?
Was I muted the whole time? I surrender. All right. I officially surrender. I will not talk midstream anymore, which is probably better.
I need to move forward. I want to get my punishment done so I can move on with my life.
I told her that she needs to do a.
Well, then you would have to plea if you.
Right.
Court to do.
Right. And
Sounds like what Mr. Brown was trying to accomplish.
Mm-hmm.
But.
So when I came in at 10.
I don't know about any of that.
Okay.
All right.
Yeah.
The only thing I can say is if you're going to plead, then we'll plead.
Mm-hmm.
Is that what you want to do?
Yes. I don't want to go to trial.
Okay, because those are going to be the only options.
Right.
So whether the meeting happened or not, did you go through the plea form?
No, we were supposed to do that at 10 and he never came to get me.
Okay. Yeah.
It's a.
Oh, it doesn't matter.
Right. Yeah.
Can somebody there do they have the forms over there? All right, I'm going to pass this into the next block. We're going to get it done if that's what it's going to be.
Okay.
All right.
Thank you very much. I appreciate that.
Go out there right now. They're going to give you the plea forms. They're going to go through everything and then we'll call it up. Thank you.
While we're doing that.
Well, you get ripped off when I mute myself, huh? Sorry. Thank you.
Are you Jacob Griffin? Actually, gonna get you. Miss Leonard.
I'm here.
Got him sitting in our jury box right now. Gosh, can we, do you mind?
You want me to move him out here? Or?
Sure, it might be easier just to move him up to the podium.
Yeah, come on this way. Okay.
Might be easier for you to see or even with the desk or whatever. There you go, sir.
One minute, seat right here.
And so you're Jacob Griffin?
Yes.
So the
Do you want to speak with legal services, Mr. Griffin?
About,
Sarah Leonard is asking to evict you from the premises, apparently where you're living at.
okay, I was living there with my wife at the time.
Are you still living there or are you?
No, I'm currently housed at Genesee County Jail.
Yeah, but I mean, besides being.
No, she moved out and I paid, I had 2 months worth of rent just to try to get my stuff out of there. I was trying to clean up the house and fix it up, and then all this stuff happened. So,
And all this kind of.
yeah, it got in the way of things, of getting things in order over there too, so.
Okay. So you just so that you.
He's got the same barber as Judge. Is it Stewart? Who's in Shaughnessy? I think it's Stewart. I can't remember.
You have a right to talk to legal services, and I've got somebody on here if you want to. If you don't.
I have no clue what legal services is. I've never been evicted from a house like this before.
Okay,
So.
they may or may not be able to give you legal advice as far as the eviction. But if it's kind of thing where you want to just have time to move, is that what you want to do?
Yeah, I mean, I just wanted to leave the house like more so intact, like in shambles. When my wife left, she kind of left it a mess, the yard mess and things like that. And
okay.
So.
How long are you in jail for?
I have no clue. I haven't seen an attorney.
You haven't seen anybody yet either. What kind of case do you have?
I'm being accused of a sexual crime.
Okay, all right, so let's just leave it as a felony case of some sort then, right?
Yeah.
Did you just get picked up or you've been in jail for a while?
SA and a hoarder, and he blames it on his wife. Ladies, I believe he will be available soon. Get your applications ready.
I've been in jail for a few weeks.
Few weeks? Okay.
Your Honor, might I insert something?
Sure, yeah.
We were asking this as a help. There's no power there, and I have pictures. The refrigerator is
I mean, it kind of depends on what you want to insert.
jam-packed full of food, rotting and smelling. The neighbors are all complaining. If I don't get something done, I mean, it's more than tidying up. It's one of the worst I've ever had since 1984. If I don't get it cleaned up, I'm going to be appearing in front of you with Montrose Township. They're going to cite me because
it's got beaver moles, Judge.
There's no power. The sub pump's not running. It's flooding everywhere. There's rats going to the neighbors. Everybody's complaining. And like he told you, he was planning on leaving anyways. He can't clean it up because he's in jail. And that's why I filed for a health hazard. It's not, I didn't file for non-pay.
Yeah.
The place is a shambles and it's so unhealthy to the neighborhood. It's really, really bad. And I've got pictures if you'd like to see them.
That's okay. I think we may be able just to work. And Mr. Griffin, just for my sake.
You want to smell it?
If you want to speak with legal service, I have them here. You can talk to them this way. If you don't, that's fine too. It's up to you.
What is the
Nah, I don't need to see it or smell it. I believe you. I entirely believe you.
legal services? What is it?
I'm going to give you advice as far as what your rights are with regard to possession of the premises. Mr. Lowry, are you there?
Hi, Your Honor. So I am here. My concern is if he doesn't know when he's going to be released. Unfortunately, we have a prohibition against assisting anybody who's currently incarcerated. So,
so you can't even.
Unfortunately, I can't.
Oh, okay. I was going to try to just let me talk to you real quick, but no.
Yeah, I mean, I from what I'm hearing, I mean, I get that not having power and the condition of the house can be a concern. It sounds to what I've heard, at least, that it sounds like he may be out or just needing to kind of clean up the final things. I just don't know when he's going to be able to be out to do that. I did look at the court record. It looks like he has a preliminary exam or something scheduled on 28th of April. So that's obviously still even outside the 10 days. So even if you gave him 10 days, I don't know that he would have the chance to, unless he's able to bond out in the meantime. So
I appreciate you doing that too for me. So he's kind of sticking his neck out a little bit for you, okay?
Okay.
So, but apparently they can't do what you need.
Well, I'm just in question because I wasn't the only one living here. My wife was as well.
Do you have belongings there still? Do you know?
Does she?
You know, are you?
Most of that's garbage that was there that needed to be thrown away.
This,
I was just trying to clear out things like that.
Miss Leonard, I think, why don't you raise your right hand for me? Do you swear from the testimony you're about to give will be the truth?
I do.
And what you've told me at this point is true, that you're concerned for the health of the premises, safety of the individuals around the area as well. Is that right?
Yes, Your Honor.
I'll grant an eviction. I can, let's do it this way though. I feel like I should give them the 10 days, but it gives you access to it, just to get house and safeguard the house from something happening. If we want to do it that way, okay? And I trust that you're going to do that.
Yeah. And the majority of his belongings were out when we went last week. I've not entered the house without the police, but I had to because of the flooding.
Yeah.
So I had a standby, and his parents were actually there in the driveway taking stuff out of the house. So there's really, like he told you, there's really not anything left there except pretty much junk. You know what I mean? Not anything that I
In all fairness, Sarah seems pretty reasonable, I have to say.
think he would be using. So what he told you on that was truthful also.
Yeah. So does that sound, did you have your parents go out to the place at one point?
Yeah, my mom said that she was out there, but she wasn't able to get the TV stand that was in the living room. That was about it.
Okay. Let's
possibly yard.
Okay, so let's do this. Ms. Leonard, I'm going to write on the judgment that I think the easiest way is I'll put down eviction after 10 days, but I'm going to put a note on paragraph 10, just an asterisk saying that you're allowed to go onto the premises, just can't move any personal belongings out of it for that 10-day period. How's that?
Okay, and if you would, Your Honor, the township's biggest concern is the junk everywhere in the yard. I mean, it's thousands of pounds. Is there anything he wants out of that yard? Because that's what the township's wanting to cite me for, is the outside.
I can see if somebody can remove it and like scrap it out. There's mower parts and stuff out there.
If she's right, what happens, the township's going to come see her. I guess, you know what? You could just tell them I've got an order for 10 days and we'll just do it that way.
Okay.
Give you our time to get 7 problems, but we'll give them 10 days to get it. Sir, if it's not though, if there's things there that after that 10-day period, she's just going to be able to take it off. Okay. Okay. All right. So we'll do it that way. Grant writ of eviction April 24th, with the exception that you can go on the property, safeguard the house, and just don't move personal property.
Right.
Just
okay. I appreciate it. Thank you.
Sir, thank you for being civil too. Okay. All right, we'll get you a copy of that. Thanks.
All right. Bye-bye.
Have you go ahead and have a seat in that third chair or second chair again. Third chair. I'm gonna put some paperwork and then we'll get you.
Let me know when you're ready. Whoa, what is that?
All right. Looks like Big and actually has to work. So we're just going to marathon stream this thing.
Really? I don't know that. All right.
We're going full
High
clip
tech.
dump here.
You and Mr. Miller. Well, let me know when you and your tablet are ready.
I'm ready.
Okay. All right. Ms. Rivers, we're going to get on the record in State versus Joyner. It's 25 SC 005 515. Ms. Joyner is here with Ms. Rios, and we have Ms. Nix for the state. Ms. Joyner, Ms. Rios.
This is going to go down exactly the way you think it will.
asked that we add your case to this morning's ad hoc calendar because you were prepared to enter a plea. Is that correct?
Yes.
Okay. The way this will work is that in just a moment, Ms. Nix is going to put you under oath, and then she's going to ask you a bunch of questions. They're going to be very similar to the questions you heard Ms. Smith ask Mr. Mitchell, but they're your questions, and we need your answers truthfully and completely. I also need you to let me or Ms. Rios know if you have questions of your own. Will you do that?
Yes.
Okay, great. Ms. Nix.
Thank you, Judge. Ms. Joyner, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, nothing but the truth?
I got a new mineral meeting, but they apparently it was boring and they behaved themselves for most of it. There were a couple little fights, and maybe I'll pick those out.
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Barbara Joyner?
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
36.
How far have you gone in school?
12th grade.
Did you graduate or you made it into 12?
Made it into 12.
Is English your native or dominant language?
Yes.
Do you understand that you've
So you're saying it was close?
been charged with the following offenses?
Yes.
Count 1, aggravated battery. Count 2, aggravated stalking. Count 3, stalking. And count 4, willful obstruction of law enforcement officers.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Rios?
No.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive a formal reading of the indictment for purposes of the plea?
Yes.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Ms. Joyner, do you remember having been arrested on these charges?
I'm sorry, could you repeat that?
Do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you're entering a somewhat non-negotiated plea and the state may recommend a sentence to the court without your having agreed to it in advance?
Yes.
Are you aware that the state's offer is 10 years that you serve 30 days with the balance on probation? You have 24 days of credit, and the state will recommend that the remaining 6 days be served on the weekends.
Yes.
With the special condition of a permanent no contact with Heather Webb.
Yes.
Have you discussed this offer with your attorney?
Yes.
Judge, I believe that her final plea was when I was in trial, so I'm not sure if she still has her final plea rights.
What do you remember about that?
She does because you were in trial. I don't think we had an offer even at that time.
Okay.
Okay.
Um,
So what that means, Ms. Joyner, we're not trying to use code. Ms. Rios is going to advocate for a slightly different sentence because I heard this was a somewhat non-negotiated plea. So Ms. Rios is going to argue for something different. If the sentence that I impose is more severe than what Ms. Rios says, so longer probation, if she says no jail time and I include jail time, she says no fine and I include a fine, anything that makes the sentence more severe would mean that you and Ms. Rios could talk about the sentence that I impose, and then you could let me know, sorry, Judge, I was willing to take what Ms. Rios said, but not what you did. And so I'd like to withdraw my plea, and you'll be absolutely free to do that today and today only. After today, if you want to enter a plea, you're stuck with whatever sentence you get. But today you'll have a chance to think about what I impose. If it's different from what Ms. Rios said, if I agree with her and say the same thing, I'm not going to ask you, what do you think about that? Because I gave you what your lawyer asked for. And it sounds like there's a small difference between the two. I have a hunch what it is, but I'll hear from Ms. Rios about that. Okay. And if it's a different sentence that I impose, I'll give the two of you and Ms. Rios, a chance to talk about it.
Okay.
So what I just listed was the offer as to count 2. As to count 1, the state will reduce to battery and offer and recommend a sentence of 12 months probation, and state will now process counts 3 and 4. Do you understand that's the state's recommended sentence?
Yes.
So the one felony would be aggravated stalking, and that's the basically 10 years to serve 1 month. And then count 1 misdemeanor now, battery, and 3 and 4 dismissed.
Yes, sir.
Thank you.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from what your lawyer might ask for as a sentence, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
That might be my new tagline right there.
Do you understand that if you are
I
on
like it.
probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Don't worry, this gets worse when the victim comes on.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
I'm sorry. Could you repeat that?
Is it your decision to waive these rights and enter a guilty plea today?
Maybe I should go with lobster head for the thumbnail.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Guilty under effort.
Okay. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes. Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at trial?
Yes.
How do you plead to the charges of battery and aggravated stalking in indictment number 25 SC 005515?
Guilty under effort.
Is this Alfred plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Love it.
Do you
Love it.
understand that if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal as outlined in OCGA 5-6-35 within 30 days of today?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for the felony, you have only 4 years from today, and for the misdemeanor, you have only 12 months from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about March 15th, 2024, the defendant came to Heather Webb's home located at 657 Boulevard in Atlanta, which is in Fulton County, in violation of a temporary protective order, which prevented her from having contact with Ms. Webb
Thank
and
you.
coming to her residence, and struck her several times, causing visible bodily injury, including bruising and a black eye. Miss Joyner was still on scene. She was in the parking lot of the apartment when officers arrived and did state to law enforcement that she knew she wasn't supposed to be there. And this occurred in Fulton County.
You guys will never believe why these two ladies got into it. Never.
the battery that you're reducing
Okay, yeah, you will.
aggravated battery to, is that just plain old battery, or because of the nature of the relationship between Ms. Joyner and Ms. Webb, would it be a family violence battery?
It would not be family violence battery.
Okay. I want to make sure that the final disposition reflects that.
Judge Ms. Webb is on the Zoom and would like to make a statement.
Great. That was my next question, was whether Ms. Webb wanted to do that. Good morning, Ms. Webb.
Good morning.
So I'm going to add you to the screen here. I'm Judge McBurney.
Indeed, there was a fight over some quality cock.
It's nice to meet you. I am here to listen to you about how this incident has impacted you, what you think ought to happen, anything you want to share about this situation.
I can't see you. I can hear you, but I can't see you.
Well, I'm there. I don't usually have.
Okay, no problem.
I'm here. I can see you. That's the important part, and the court reporter can as well.
Okay, thank you. Well, I have wrote a victim statement, and first I want to say thank you for allowing me to stand before you today, not just as a victim of crime, but as a woman who has endured prolonged harassment, threats, and trauma. And yes, I am a little emotional because, yeah, this was a lot. At the hands of the defendant, for several years, I was subjected to stalking, harassment, and escalating acts of violence, which was began as unwanted contact that turned into a pattern of disturbing behavior that made me feel unsafe for my life. On the evening of March 15th, all of my fears came true. I was completely violated in my home. I lived in constant anxiety, never knowing where or when the next encounter would occur. My sense of peace, security, and normalcy was taken from me. The final assault was not just attack on me, but a threat for my life. I was physically beaten and kicked at my right eye, and kicked where I had just recently undergone a kidney transplant. I was completely afraid for my life. I could have lost my life, not only lost my life, but lost my eye to this this incident. My body was in a vulnerable state, but critically to my life and survival. This was deliberate, target, and dangerous. Your Honor, I can hear the defendant saying, while she kicked and beat me, excuse my French, die slow, ho, over and over again as I begged the defendant to get off of me and stop kicking me. Even with the TPO in place, the defendant on more than one case has still made it her business to violate the TPO and constantly harass and stalk me. On the evening of March 15th, I had just recently returned back home. So to find someone knocking at my door at that time of night, I was very unexpected. As a result of this attack, I was taken to Grady's Trauma Center, where I prayed everything was going to be okay, especially with my kidneys. Physical bruises, as far as my eye would be healed, but my kidney, once that was gone, that was it. Not only to mention that I have also had open heart surgery, where I sustained severe pain after the incident as well. Difficulty sleeping, mental burden of the whole situation has left me drained. No one deserves to live this way, stalked and harassed violently and attacked, especially over a prolonged time prolonged period of time. I'm asking the court to take into full consideration of the severity of the pattern that was intended by the defendant actions. This wasn't just a one-time incident, it was repeatedly escalating behavior that resulted in serious harm. I'm asking for accountability. I'm asking for a sentence that reflects the seriousness of what I have endured. This was excessive and uncalled for. Thank you, Your Honor, for hearing my voice.
Well, you're very welcome, Ms. Webb. And I know it was difficult to talk about this and have to relive it. It's been a couple years now, and here we are having to get back in the middle of it. I have a few questions for you. How did it work out with your kidney? Was your kidney okay?
Well, I've actually had, since this incident, I had to have a kidney biopsy done since that, which caused me to have a stroke and also 2 more heart attacks. And I've had to have 2 more open heart surgeries since this incident.
And how about your eye? Did it heal?
My eye healed.
I've had 17 open heart surgeries and I'm blind as a bat. I'm not saying she doesn't have some issues. I'm just suspecting there might be some exaggeration in here.
But I still have plenty of vision problems with that eye.
Okay. Well, I'm sorry to hear that. Since this incident, since this bad night on March 15th of 2024, has Ms. Joyner stayed away from you? No visits, no phone calls, nothing?
No, she hasn't directly, but she has been in spaces where she knew that I would be.
What's an example of something like that? Because I'm going to be giving Ms. Joyner some pretty clear instructions.
July 4th to be exact.
Like last year?
I mean, it's not impossible, but you know, I'm an attorney that makes these arguments for a living. It's tough to sell a traumatically induced heart condition. It's possible. It's possible if you take a blow directly to the heart, say. But it's not easy.
July 4th?
Yes, last year, July 4th.
Okay, but what's are you guys relatives, or why are you thinking?
No, we're not relatives. I'm dating someone that she used to date. That's where all of this is extended from.
Okay, but why would you all be in the same place for July 4th?
Love, exciting and new.
From my understanding, she was invited, and no one in their family knew the extent of what was going on between me and her, but she knew.
Okay, but it wasn't that. I understand, and so going forward, Ms. Joyner would need to leave if she got to a place and you were there. But it wasn't that she invited herself, someone who didn't appreciate the situation.
It wasn't that they didn't know of the situation.
Okay, to me, that's the same thing. They didn't know. And so they thought, hey, I know Ms. Joyner, she's great, want her to be at this event. I know Ms. Webb, she's great, want her to be at this event. And that was a bad coincidence.
Mm-hmm.
Okay, but apart from that, which I'm not going to lay at Ms. Joyner's feet, this other person doing the.
Yes. If your blood type is gravy, the defense attorney from the insurance company will point that out repeatedly. Let me assure you, I've been at that deposition.
Invites. Have you been able to not obviously forget about what happened, but move forward in your life with your significant other without Ms. Joyner getting in the way?
Well, that part doesn't even matter. It was all about her responsibility. The other person didn't have anything. That's accountability for the person that is doing the harm. That has nothing to do with the other person.
Okay, I didn't mean it that way. I didn't mean it that way, and I guess I didn't ask the question well. Over the last 2 years, other than this 4th of July event, have you seen Ms. Joyner at all?
If
Seriously, Judge McBurney, ask better questions. You're screwing this whole thing up. It's smooth as silk except for you and your clumsy questions.
I must say yes.
Okay, and what was the situation?
She knows where I live at currently.
Okay, all right. Anything else, Ms. Webb, that you want to share with me?
Other than I feel like, the whole situation could have been very well avoided. I asked her on several occasions, even down to when she first, informed me of who she was, to leave me alone. That was like completely ignored. If you go back and take a look at the evidence that I presented, I have never, engaged her with conversation. It was always directly towards me. She found any kind of way to make sure that I knew that she was around, whatever it was, whatever she was trying to do, run me off. But also on the evening of March 15th, this young lady came all the way from Stonecrest Mall, all the way downtown Atlanta in an Uber or Lyft, or whichever one it was that she found her.
All the way from Stonecrest Mall in an Uber. Why does it matter? I don't know, but we're going to hear about it.
Way past Keller Road where she lives at to come to my home. And this wasn't just one occasion. On second occasion, she came to my home and threw clothes in front of my home. In the pouring down rain from the other person that is involved, that tied all of this situation together.
Got it.
I don't think she's strong enough to throw your clothes.
This not for me a slap on the wrist, because I could have very much been back on dialysis. I could have very much lost my life.
Okay. Well, I understand why you were afraid. You got a protective order, and Ms. Joyner didn't follow that. And if that doesn't protect you, then what is going to? So I can understand.
What was protecting me? And the thing was, right before this incident happened, I received a text from an anonymous number texting me saying, "This Barbara, I'm gonna beat your ass." That's what the message said. And then a day or two later, the incident happened.
Okay.
I went down to the police officer again, and I kept telling them, this is going to turn bad. And it did.
Right. Well, I'm sorry you had to go through that. And I appreciate you being here, because it adds a lot of depth to what Ms. Nix was sharing about what this case was about. So thank you for sharing your time.
You're welcome. Thank you.
You bet. Ms. Nix, did you have any information about criminal history for Ms. Joyner?
No, sir.
Okay. Ms. Simpson, do you have anything?
She's not assisting, so I'm gonna assume she has no felony convictions.
Okay. The only arrest showing up in Odyssey is this case. Ms. Rios?
Yes, Your Honor. Ms. Joyner, 36 years old. She has 3 children, ages 14, 15, and 18. She, for a period of time, was homeless, living out of her car in homeless shelters with her 3 children. She just recently got a job working in a kitchen. She provided me with proof of her pay stubs, and she just got.
When you say working in a kitchen, I got a restaurant?
School
kitchen. Okay.
Yes, and then and she just got a place to stay. So she finally has a home after being homeless for what, a year? A year struggling, dealing with this, homeless, no job. And so now she's finally.
Keep going.
And now she's finally situated. All of this is over a man. She was dating him. She sent me several pictures of them together. He was dating her and the victim at the same time. So Daniel at the same time, and he had actually texted her
Her confirming it as if we doubted it is just too good.
to come over to get her stuff. They were fighting. He was like, "Come get was your keys or
Yes.
something."
When you say her, you're referring to Ms. Joyner.
Ms. Joyner, I'm sorry.
So the man, what's his last name?
Sims.
Mr. Sims texted Ms. Joyner saying, "Come get your stuff."
Yes.
Okay.
And so she went to the location, not knowing or realizing it was her location. I did watch the body cam and I did try to listen to where she says, "I knew I should have been here." I didn't hear that. And maybe I've missed it because it was a lot of body cam. The first thing I heard her say was, "She hit me first. I was attacked." So her side of the story is when she got there, and he was there on scene too. The man was there, Mr. Sims.
Mr. Sims.
And her side of the story was she got there, she knocked on the door trying to get her stuff. She comes out.
She meaning Ms. Webb.
Ms. Webb comes out and they started fighting.
Okay.
And so she was hysteric and she maintained that on the body camera saying that she hit me first, she me first. They just were fighting. She did know she had the protective order, but she didn't know she was going to be at the location or know that was their location. I don't think she'd been there before. So what?
You get a chance, Ms. Joyner. Let Ms. Rios talk for a little bit and I'll turn to you.
So, and since this incident and since she's no longer dealing with Mr. Sims, she has not had any contact or purposely. I know they were at the same location at that one time, but she's maintained that she never had any contact with him. It sounds like from what Ms. Webb saying that they haven't spoken. That's the gist that I've gotten from it is they haven't had contact since the situation. So she understands the situation. This is why we were taking a plea, because it was still aggravated stalking. She wasn't supposed to be around. And maybe when she got there, she should have just ran. But she was saying that they started fighting and this has been bad blood between them for a while because of this man. The reason why it's not a full negotiated plea is because with work and her taking care of her children, even 6 days in custody would be difficult for her. This happened a while ago. Since then, she hasn't had anything in her history. She doesn't have a history. It all seems like this situation is a last, and she's 36-year-old, it doesn't have a history. Because of this man is what got her in trouble. Of course, she's taking responsibilities while she's taking a plea, but if it wasn't for this situation, she would not have any contact with the police. So I'm just asking for her not to do the 6 days, for a behavioral incentive date of 3 years, and arrest to be negotiated.
When you say the rest to be,
the rest is as negotiated.
which I have.
Did the attorney just axe? That's so depressing.
As the absolutely no contact with Ms. Webb.
Yes, sir.
Okay. Ms. Joyner, where is Mr. Sims now? I don't mean physically, is he on Boulevard, but is he someone in your life right now?
No,
Okay.
not at the moment.
You say not at the moment. In the last,
I'm saying that.
Not at the moment, which means she's available at any moment. It's pathetic. Mr. Sims is nothing special either. He's nothing special.
Because I have dated this man. We have history.
you and Mr. Sims have history?
Yes.
History as in a romantic history or history as in?
Meaning like a bonds, like with family members and even his daughter. I took care of his daughter for.
We have a bond. Holy shit. You don't have a bond. You have occasional bad sex. That's all you've got. And not even that anymore.
A whole year.
Okay.
And Miss Webb, she knows all of this.
Okay, but let's not talk about Ms. Webb. My question was, is Mr. Sims someone who's still in your life?
No, I cut all ties.
Okay.
Because at the end of the day, I don't want to get in trouble. And
at the end of the day,
I'm not a troublemaker. And this right here has really stressed me out. Like she said, I have kids. I don't have a criminal history. I don't get in trouble. I don't do things like that. I was just wrong place, wrong time.
And this lady, as I stated with the police, she can't answer the door, me not knowing because I heard his voice the whole time. I never once knew she was there or, you know.
So you had a protective order against you at this time.
And I didn't even know how I got the protective order. I never, like, she did all this. How did she get my address? Don't y'all see that she was the stalker? She was the one aggravating and trying to provoke someone.
So no, I don't see it that way. And if she got a protective order, that meant she got in front of a judge who decided that there was a reason for you to stay away from Ms. Webb. So my
Ooh, look at Judge McBurney. He's not buying the defendant's "I'm actually the victim" speech. I'm shocked, and he confronts her on it.
question was simply,
But it wasn't.
you know what?
Okay.
Like a Boy Scout, but confronts her nonetheless.
I just wanted
To answer the question.
Okay.
I promise I'm gonna hear you out. Let me get the question out.
Okay, go ahead.
When you got a copy of the protective order, did it say, here's where you're supposed to stay away from, or did it just say, stay away from Ms. Webb? Because sometimes it'll say, don't go near 123 Walnut Street.
It just said stay away from Miss Webb.
It didn't have any addresses
No,
on
it did not.
Okay. Do you have a copy of the protective order? See if you can find it.
Because I don't know her address. I never knew her address.
Okay.
For it to say to stay away from her.
Okay, so you knew you were supposed to stay away from her, but you didn't necessarily have an address in mind to stay away from. So on this date,
Right.
March 15th, when you went to an address, because Mr. Sims said, come over here.
Right.
Was that an address you had ever been to before?
I've been to the address with him because his auntie had a color party, and that's how I know the place to go. I never knew the actual physical address. I just knew the place to go. And yes, he did tell me, well, come get it. So I'm like, okay, cool. Because at this point, I'm fed up. You over there with her, this back and forth. I don't have time for it. It's drama in my life. I don't do drama. So yes, I wanted to be an adult, knock on the door, get my things, and just leave. But Ms. Webb came to the door swinging on me, and that's how we got to fighting.
She doesn't do drama. Let her go.
I did not initiate and I never kicked this lady, never.
What did Mr. Sims do while this was happening?
While all this was happening, when I knocked on the door, his response, and like I said, the whole time I was talking to him, I never heard her voice, never spoke to her. She never came to the door, except for when she came to the door and started swinging on me for us to get into an altercation. But he said, hold on. I held on. I knocked it in because he never came. They turned the music up.
The only thing I'm guilty of is loving too much and winning the fight.
And at that point, my conscience, he had to be with somebody, I guess. I didn't know who he was with. I'm just trying to get my key and leave. So he said, hold on. He never came to the door. Next thing I know, she opened the door, and then that's how we got into the altercation.
Right. And what did Mr. Sims do while you and Ms. Webb were?
He ran. He stood there. He didn't do nothing.
Okay.
He didn't do nothing. Like, he didn't try to prevent her from attacking me. He didn't try to break no argument or a fight up. He didn't do nothing.
Okay. All right.
Excuse me, Your Honor.
You know what, Ms. Webb, I don't want to have a back and forth about this, and you are not on trial. You haven't been charged with anything, so you don't need to defend yourself in any way. You've already shared with me the impact this has had on you. It's been a profound impact, and this really isn't the right forum to have a back and forth, okay?
Okay.
Thank you.
Judge, this is a DeKalb TPO, and I have that it has been requested, but I do not actually have it in my possession.
I don't have it either. I just was curious if that was something that law enforcement had given you as part of discovery. Ms. Joyner, what are the hours that you work at the, I'm gonna call it this
7 to 3:30.
cafeteria? 7 to 3:30. And when you're there, where are the kids?
They're at school.
Okay, this is a boring back and forth. I'm going to jump ahead to this sentence. She pleads.
I thought Ms. Rios would tell you it wasn't a secret. It just we had time to kill because you were working with Mr. Mitchell.
goodness, when do you go?
July 1. So I don't go, I'm right here. And Judge Ellerby will be, so you're going to be 2 doors down. We'll visit. I'll slide the candy down there. Deputy Gordon may end up in there because the sheriff's team has said you don't have lots of inmates in the family division. And so they can get a deputy who moves at a different speed for a family judge. So it may be that the only thing you're missing is the ornery judge. So you'll be in a great spot. Same docket. It just goes down there. It is obligatory. And Ms. Rios can explain to you why I went July 1 instead. I had to go July 1 or
Okay, I give up on it. I'm not going to look for it. He takes literally 20 minutes to take the plea and say, yeah, you've got to go to jail, and tries to work out weekends and all that crap. But she gets sentenced. That's all that's going on here. But that's not the fun part. The fun part was them trying to out-victim each other. All right. I've got one more. It's from Alyssa. Proceed at your own risk. I do not know what's going on.
Miss Wiggins, can you hear me?
Miss Wiggins.
Okay,
Yes, I can hear you.
Okay. All right, Miss Wiggins, we're going to go forward on your motion at this point. Let me just review a couple things with you. Hold on a second. This is the wrong case.
Yeah, in case you hadn't noticed around here, the bright unnatural hair color, it's not always, but it's an indicator you might be dealing with crazy.
All right, so Ms. Wiggins, you've set, so I guess you did a motion to set aside the writ, I guess in this case. The motion stated that you well, let me go ahead and place everybody under oath so I don't forget to do it. Ms. Wiggins and Mr. Johnson, if you could both please unmute and raise your right hands. Ms. Wiggins, you got to unmute for me.
She froze. I haven't seen this. This is going to be a shit show.
Okay.
Ms. Wiggins, can you hear me? Okay. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Yes.
Okay, you can both put your hands down now. Thank you so much. Okay. All right, Ms. Wiggins, you're here on your motion. I guess I'm going to call it to set aside the writ in this case. You filed a late answer, or the motion states that you tried to file an answer, but that it came back. I don't know. What exactly did you say happened with your answer?
So I went to the magistrate court to file the answer, and the clerk was unable to find the case. And so she gave me back the paper that I completed, and it had the time and date stamp on there along with her initials, but they didn't connect it with the case because for some reason she didn't locate the case when she looked
You
for
didn't
it.
locate
I
the
don't know.
case? That doesn't make any sense. Did you have
No,
the case number?
Well,
They wouldn't have stamped it.
Clerk's initials. I don't know what her name is, but oh, she stamped it. It's there with my motion that they scanned it in with the motion that was given to you.
They did? Okay, let me look at it. I
Yeah.
didn't see that.
She stamped it before she looked.
Okay, this says urgent writ has been issued. So this is something you filed. So that you said you attached your original answer to your motion?
Right. Yes, if you keep going through the next pages, there's probably about 5 pages. There's the
February
pages that
24th. Hold on a second. So you were served
February 17th, Judge.
February 17th. That means your answer was due. Look here.
February 24th would have been timely.
Okay, all right. All right, so I'm gonna give you the benefit of the doubt on that, okay? So, it looks like she tried, for whatever reason, let me see. Let me look at it one more time.
Judge, not to cut her off, but the confusion might be this case was filed in state court.
Oh, well, that would do it. Yeah, that is, okay, you filed it. You went to the magistrate court clerk. They should have.
Yeah,
still
that's
been
what the
able to find
paperwork.
it. Yeah, it still should have been accepted there. I'm not sure why that would not have been. Well, you didn't put the case number on it. That's probably why. They might have had trouble finding it because you didn't put the case number on it. So, but nonetheless, I do see that this answer, it is stamped February 24th. So I'll go ahead and I will go ahead and give you the benefit of the doubt that you did try to file on a timely answer. Okay, so that means you can have I know you're stating that that no sale, that they don't actually own the property. So at this point, we're just going to go back and have this. Since I'm accepting her answer, it looks like she did file an answer. It was stamped by the clerks. I'm not sure why it didn't register into Odyssey, but I'll go ahead and give her credit as having a timely answer, Mr. Dunham. So at this point, it would just be a matter of if you're stating that your client purchased this property, you can go through all of that. If you have the deed and everything.
I have all that. Can we proceed with that now?
Yeah, just real quick, Mr. Breedlove, do you have an announcement real quick? Let me just let them out of here.
Yes, right. We have a consent on 19 with Ms. Hill while we still have her.
All right, Ms. Hill, please turn your, I know, right? Ms. Hill, please turn your camera on and unmute.
Yeah, she had it on and was unmuted in the breakout room.
Ms. Hill, you've really got to get your camera on. She was driving before, so I have a feeling that had something to do with it. All right. It's on now. Yes, if you can just leave it just like it is. Don't touch anything. So
that's straight porn name right there.
Make sure you don't lose you, okay? Okay. All right. Go ahead, Mr. Breedlove.
Consent writ of possession, Judge, April 30th. Judgment for past due rent and fees through April 30th, $8,850.58.
Okay. All right, Ms. Hill, I just need to review this agreement with you very quickly. I do need to place you under oath in order to do that. If you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, thank you so much. Okay, so it looks like you've agreed to vacate the property by 11:59 p.m. on April 30th, and that they're meaning that if you are still in the property beyond that date, then the landlord can then apply for something called a writ of possession. That's the document that would allow the landlord to have the marshal come out at some point, okay?
Okay.
Okay, and then there would be a money judgment against you representing rent through the 30th in the amount of $8,850.58. Is that what you agreed to?
Yes, ma'am.
All right, unless you have any questions, you are free to go.
All right, thank you so much.
You have a nice day. Thank you.
Thank you.
All right. Okay, now we can, and Mr. Breedlove, is that it for you?
Yeah, but that's all I had, Judge.
All right, you have a nice day, sir. Thank you.
You too. Thank you.
Thank you.
All right, thank you. All right, so Ms. Wiggins, if you could turn your camera back on, so what we're going to do now, so Mr. Dunham, I'm going to let you present your dispossessory case, and then we'll go from there. Ms. Wiggins, you do have to have your camera on.
May I share my screen, Judge?
Just one moment. Ms. Wiggins, please find a seated or standing position where you can be still. If you could stay there, somewhere you have a better connection. Wherever you were before, it was not a good connection. So if it sounds like you're probably in a good spot right there because I can actually see you and you're not freezing up. Can you stay there?
She's muted, Judge.
Yeah, I know. I'm just trying to keep her from going back to where she was because it was not a great place to. All right.
I'm ready.
Okay. All right, she's ready. It looks like she's going to stay where she's at there. Go ahead, Mr. Dunham.
May I share my screen, Judge?
Yes. Excuse me. Ms. Wiggins, while they're testifying, I'm going to put you back on mute.
Okay.
All right, go ahead, sir.
All right. Mr. Johnson, you're the owner of Synergy Investing, is that right?
Yes.
All right. I'm going to put on the screen a document that I've labeled Plaintiff's Exhibit A. Do you see that?
It's not shared. It says you shared your screen, but it's dark. It's just blank. It says double click. There's nothing. We can't see anything for some reason.
Stop it and try again. Sure.
Ms. Wiggins, I am going to ask, please keep your camera stationary. It's distracting. It makes me dizzy, frankly. So just please keep everything still.
How about now? Can we see?
Yeah, we can see that now. Yes.
Thank you. Mr. Johnson, have you seen the document that's on the screen marked Plaintiff's Exhibit A before?
Yes.
What is it?
It's the contract that we signed with Michelle Wiggins, or Maria Michelle Wiggins.
Now, Ms. Wiggins is not listed as the seller in her personal capacity, is she?
No, she's listed as a personal representative of the estate.
Okay. Do you know who Pansy Germany is?
Yes.
Who is it?
The deceased.
Okay. And Ms. Wiggins, is it your understanding that Ms. Wiggins was appointed as the personal representative of her estate?
Yes.
Okay. Briefly describe for the court what this document obligated the parties to do in this case.
Our company, Synergy, reinstated and paid off the mortgage on the property that was facing foreclosure. And in exchange, we took possession of the property through deed transfer.
Right, without permission.
I believe it was an administrator's deed.
Okay. I'll put on the screen a document that I've marked as Plaintiff's Exhibit B.
Can you scroll down to the signatures again, please?
It says my
On
screen
PA.
sharing is paused again. There we go. Mr. Johnson, these were electronic signatures, is that right?
Yes.
Okay, I see, and it was signed on 9/23/25.
Mm-hmm.
Is that correct, Mr. Johnson?
Yes, it is correct.
Okay. Now, you took title to the property, or Synergy took title pursuant to an administrator's deed. Is that correct?
Correct.
My screen sharing keeps cutting in and out. I am blaming the Cobb County Courthouse Wi-Fi, Judge.
That's all right.
I'm hoping it comes back.
We're doing that. Ms. Wiggins, do you have any legal objection to PA coming into evidence?
What's PA?
It's what he's sharing on his screen right now. The agreement that you signed saying that they could have possession of the property and they paid off the mortgage on your house.
They can submit that, but I never agreed to selling them the house.
Is there a kitten meowing in the background?
For $46,000. That was never a deal. They never offered
Hold
it.
on. All right, I'm just
This is
asking,
all
do you have any
fun.
legal objection to this document coming in?
Judge, I made a solution.
I mean, they can present it to you by all means, but I have an objection to the entire document. Yes.
Okay. All right. PA is admitted. What's your next one?
My next, and I've lost
Okay, admitted.
my witness, I think.
He's right here. He's here.
When you don't state a basis, that's like, it doesn't matter. It doesn't matter at all.
Okay, good. I've still not got the ability to share. Let me try stopping and starting again. I apologize, Judge. This is terrible.
All right.
Right.
All right. Can you see my screen?
Yes. Miss Wiggins, okay, I'm gonna put
Yes.
you back on me. If you could stop eating, ma'am, if you could just,
Well, I'm hungry.
this is the proceeding.
Mr. Johnson, can you see plaintiff's exhibit B that's on the screen?
You're muted, Mr. Johnson.
Sorry. It just cut away.
Yeah, I know, right? Mr. Johnson, are you he's frozen now.
I think he is. I see him unmuting. Jeff, are you there? And now am I the one frozen?
No, you're good. Mr. Johnson is frozen.
Am I back?
I can hear you. Can you see my screen? Can you see exhibit B on your screen, on my screen?
Yes, I can see it.
Okay. Is this a copy of the administrator's deed dated November 19th, 2025, by which Synergy took title to this property?
Yes, that is correct.
You see that the grantor is listed as Maria Michelle Wiggins as administrator of Pansy Lee, Germany.
Yes.
And if I scroll down to the second page, you see a signature over a signature block for Maria Michelle Wiggins as administrator.
Yes.
You understand that to be Ms. Wiggins' signature?
Yes.
Tender exhibit B, Judge.
Okay. Any legal objection, Ms. Wiggins, to this document?
Yes.
What is it?
I mean, I never saw a deed or signed a deed, point blank, period.
You're telling them they forged your signature? Is that what you're saying?
I'm telling you that I have signed things with them to agree with them to work, to put me through probate. The reason I was supposed to go through probate is so that I could talk to my mortgage company. They wouldn't talk to me before I was wanted personal representative.
He said that they paid off the mortgage on this house in order to get possession of it.
Okay, well, they did not tell us that. That's not what was presented to us, that they were paying off the mortgage to get possession of the house, to buy the house. We had cash offers of $500,000.
Go back to that.
This is a
You're going to get your, I just want to know, ma'am, if you had a legal objection. It sounds like I didn't hear a legal objection. It's a filed, I can take judicial notice of it. So the administrator's deed, PB, will be admitted. Can we go back to PA?
Yes, ma'am.
Any objection? All objections.
She's saying that she's denying the terms that you got. Do you have anything that he's saying that they paid the mortgage off and that in return for that, she agreed to give them to title of the property? Where in that document does it say that? Because she's saying that she was never told that.
So the document says that the buyer, that Synergy, agrees to purchase and seller agrees to sell the above property for the sum of, and then it's described below.
Can you go back to that document on your screen?
Oh, shit. I'm sorry, Judge.
That's all right. That's okay. That's all right.
It seems like every time I change documents, it freezes on me. So I'm going to unshare and reshare and see if that fixes it.
Hopefully, all right, Ms. Wiggins, this document is back up. I want you to please pay attention. He's going to find the paragraph on here.
So I'm at the top of the document. I'm scrolling down to the first substantive section of the document, which is entitled Purchase Price, Reinstatement, and Earnest Money. And the first sentence says, buyer agrees to purchase and seller agrees to sell the above property for the sum of, and then see below. And then
$40,000.
The total payoff for all liens at certain encumbrances not to exceed $40,000. It also provides that Synergy Investing LLC agrees to complete any repairs needed on the home not to exceed $30,000. And all parties agree that when Synergy sells the home, seller will receive all proceeds, meaning the estate will receive all proceeds minus whatever Synergy has paid.
So are they making
I can have Mr.
profit
Johnson
on
tell
this?
you about that. They're going to make a profit by putting in some money and then selling the property.
For as much, okay, for more than she could. Okay.
Correct. And so just to kind of shortcut this a little bit, Judge, since our we're having some glitchy stuff. I can have Mr. Johnson testify about all of this, but I have two more exhibits. One of them is a temporary occupancy agreement whereby Ms. Wiggins agreed to vacate the property by January 1st so that Synergy could enter the property and make the repairs that are needed and sell the property for maximum value. And then the other exhibit I have is a payment register showing that Synergy shelled out $30,000 towards this property.
Okay. What's the next exhibit? PC?
PC would be the temporary occupancy agreement.
Okay. Can you share that?
I'm forgetting. Stop. And reshare. Okay, PC is on the screen. Mr. Johnson, do you see that?
Yes.
Is this the temporary occupancy agreement I described for the judge just a second ago?
Yes.
And on the second page thereof, do you recognize Ms. Wiggins' signature underneath the block that says for the sellers?
Yes.
Tender PC, Judge.
All right. Ms. Wiggins, do you have any legal objection to PC coming in? And again, I am going to ask you one more time to just hold the camera still. If you could please do that, that would be helpful. Thought you're moving it around a lot. If you could unmute for me and tell me if you have any legal objection to this document coming in. You're muted, ma'am.
Yes, I do.
And that would be what?
I do object to all the documentation that they have, period.
Okay. Do you have any legal objection to this document coming in?
Yes, I do. And also, I have a question. There's supposed to be an attorney, Elizabeth, on this particular motion. Do you know what happened to her? Or?
And I don't know what you're talking about. You filed the motion. There's no attorney.
Oh, okay. Well, I'm sorry. Online, I got it said that there was an attorney on the.
Okay, I don't know what you're talking to, Ms. Wiggins. I'm talking about. I'm not hearing a legal objection to the document, so it'll be admitted. Go ahead.
All right, thank you, Judge. And then Exhibit D will come up next. And the label is a little bit lower, so I scroll down first. Mr. Johnson, have you seen Exhibit D before?
Yes, these are payments we've made to Ms. Wiggins already.
And I did not add those up, but have you added those up?
It's $30,000.
Okay, and this is money that Synergy has actually paid towards this property?
Yes, she's received this money through
So when you
Zelle.
say she's received, there was a separate provision that obligated Synergy to pay off the mortgage. Did any of this money go towards the mortgage?
No, this is additional money we sent her up front to help her move out of the property. And it was sent in good faith to help her move, secure a new place to go. And, and we are where we are now.
Okay. So,
advanced equity.
Yes, correct.
So Judge, I think that's our case.
All right. Well, let me just ask, Ms. Wiggins, do you have any legal objection to this document coming into evidence? And again, saying you don't agree with it is not a legal objection. You have to actually give me a legal objection. If you'd like to unmute.
I have a legal objection to every single document they have.
And tell me what it is.
Ma'am, are you a whore?
What is your legal objection?
What is the objection? The objection is that they never, yes, fraud. The whole thing is fraud. They're equity skimming at its finest. I've talked to several attorneys who have totally broken it down for me, what they're doing. First of all,
all right, Ms. Wiggins, I'm not hearing a legal objection to the document coming in.
Well, that's a legal objection if it's fraud.
I will admit it. You're going to have your chance in a second, Ms. Wiggins. I'm just asking you a simple question. It is a legal objection. You keep saying it, but you're not giving me one. Okay. All right. I'm going to admit PD over objection. What is your next topic, Mr. Dunham?
So Judge, that's basically our case. The answer, even as drafted, and obviously I have an objection to you considering it late. I think you filed it in the wrong court.
You're breaking up, Mr. Dunham.
But
you're
I
breaking up.
Sorry. I haven't moved.
Right. For whatever reason, you were breaking up.
Hang on one second. Let me see if I can do something to speed this up. Hopefully that will help. All right. Sorry, Judge. But, basically, the answer that you did draft that you've accepted late just says plaintiff is not my landlord. And the evidence that we put forward has shown that Ms. Wiggins agreed to sell the property to Synergy. Ms. Wiggins did, in fact, convey title to the property to Synergy. Ms. Wiggins also agreed that she would leave on or before January 1st. She agreed to that in writing, and she signed that. And Synergy has not only paid off her mortgage, but has also paid her $30,000 to leave. And now we are 3.5 months past the date that she was supposed to vacate, and she's still there. So I would point out, Judge, that a writ of possession will allow us to clear Ms. Wiggins out of the property and allow Synergy to enter the property to do what it was supposed to do. And if there is equity in the property beyond what Synergy is due under its contract, that will go to Ms. Wiggins as well. So her objection that is stated in her answer is quite frankly false, because she said she never sold the property to Synergy, and I've given you 3 documents, 2 of which have WEDIC signatures that match the one on her motion to dismiss, that show that that's not the case. So she can accuse us of fraud all she wants. She hasn't done that in this case because there's no counterclaim pending. And quite frankly, it looks like she's perpetrating a fraud on the court by filing something that says she didn't sell the property when in fact she did. So we're just asking for a writ of possession. Actually, we've already had one. I don't know if that one has been invalidated by the court's acceptance of her late answer. We actually had a set
it came back. It was sent back from the marshal, so it would need to be resubmitted.
Okay, and the marshal actually had a set out date of May 4th. I'm sure we've lost that date now. So she's bought herself another probably 2 months by doing this as a practical matter. But that's all we want, Judge. We just want a writ.
Okay, all right. All right, Ms. Wiggins, do you have any questions for Mr. Johnson before I move to having you testify?
No, I don't.
Okay. All right, so then we're going to move over to Ms. Wiggins. Ms. Wiggins, you just saw all the documents just presented. It looks like you have signed off on an agreement to sell your property to these folks and that you've accepted substantial financial benefit from that deal. Tell me why that is not true. You're saying that you didn't accept, they didn't pay off your mortgage, they didn't give you $30,000.
No, I did not say they did not pay off.
What did you, or what are you, on what basis are you?
Well, what I'm saying,
Judge, I want to sell my house and get all the benefits of selling it, but also keep my house. I think this should be pretty obvious.
is they trick. Okay, the whole thing was trick. I mean, everything they said was not true. Everything, every time we heard from them changed. I offered to pay them back in full months ago for the things that they paid to stop the foreclosure. They came and sat in my living room and said that what sets them apart from the other foreclosure solutions companies is that they try to keep the client in their home and not have to lose their home. And they have all these different ways of doing that. And they don't make cash offers. And there's not been one person in that company there that's even looked at the house, has done a tour through the house, who knows the condition of the house to even.
Right. But ma'am, they paid off your mortgage and they've given you $30,000. Why would they do that?
Okay, they told me had to be reimbursed to them. They said it was a loan. Okay. And I have that in writing here. I can read it to you. They have told me that they are to be reimbursed for every single thing that they've done, plus $75,000 equity.
Okay, ma'am, you have
he told me
there's a deed transferring title to the property to them, and it has your signature.
Right, but I never saw that deed. Never.
You signed it. You're saying
no, I did not. No, I did not. They forged a signature, point blank, period. That's all there is to it. I never signed it. My daughter, excuse me, they didn't. I did not sign that deed. And there's not a signature on the same page as any of those documents except for one. And I agreed to move out on the 21st, but that's when I was talking to attorneys and realized that this equity skimming situation, the $75,000 equity share, which made no sense. And it didn't go along with the whole, we have a flat fee and nothing more.
Right. Whoever's talking in the background.
That's my daughter. She's the one that called them up and started this whole thing with them. And to tell you the truth, it was completely under duress. Let me tell you, when they were at the house, I stormed out of there. I was very upset and angry, told them I didn't want to work with them at all. And the guy kept texting my daughter, please talk your mom into talking to us, please. And they knew good and well that I wasn't going for it and told me every little thing they could to try to make me think that, before we were saving the house. When I was able to sit down and think about it and talk to a few different people, legal aid and different volunteer attorneys and stuff like this, I was able to say, well, you know, this isn't right, and it doesn't make any sense at all, because when you read what Synergy wrote down, because I asked them like maybe 60 times to give me a breakdown of what costs had been incurred and what was owed to them. Okay. And first of all, it was always different. I mean, just yesterday, or maybe the day before yesterday, I was still asking Jeffrey for the exact cost incurred. Okay. Because I sent them a cease and desist letter on January 21st when I was realizing all these things weren't adding up. When you add up their costs incurred, it totaled up to what they paid to get me through probate and paid to the mortgage, plus the $30,000 quote unquote equity share, plus their $75,000, you know, all of that stuff totals out me zero and them way up over $200,000. It makes no sense. And Judge, respectfully, when my mom passed away, we had 2 people walk up with $500,000 cash offer. Okay. Because it's a very prime property. It's a corner lot. It's in, you know, Brookhaven area. It's just, you know, even our neighbors were coming up offering $400,000, $500,000. Now, there's no way I would have gone with this situation. There's just no way. We've had this house for 55 years. Okay. It's been, my mom and dad had it for 53, and now that they passed, it's 55. You know, my daughter and her kids have lived here for 9 years. This is their place of residence for 9 years. I would have never agreed to do that. And I'm telling you the honest to God truth. You did not sign. You know, I did not sign a deed over. And if I signed something that he put to the deed, he didn't tell me it was to put to the deed. Okay, I swear to you that.
You didn't read the documents you were signing?
I never signed a deed. I never saw the deed. It's ridiculous. I saw it online on the court website. It says that I signed the deed over for the sum of $1. That makes no sense at all. I would never do that. Never would I do that in a million years. And I was having cash offers, like I said, and these guys sat in there. They're like, we're from the Buckhead Church, and we're working for God, and we're just here to save your home. And the whole probate thing was supposed to be so I could finally be appointed administrator, so I could finally have the right to talk to the mortgage company, and they would give me the available options, you know, that were available to me as the successor of interest. But I was never given that opportunity because the probate attorney that represented me was Jeffrey's closing attorney. And I was, you know, I was thinking, okay, this guy's helping me get to the mortgage company where I can talk to him and everything's going to be okay. You know, that's what I thought what they told us in the beginning would be $45,000 in the end flat fee would be for. You know, the whole thing's just not right. And then, okay, and my daughter's talking too, and then another thing, my own personal record. Go ahead.
You can't be when you're testifying. She's not supposed to be influencing you or giving you, telling you what to say. So she needs to stop doing that.
Well, she's not, but she's the one that started this whole thing with these people. Like, they are really the ones. They sent her the money, actually, not me, by the way. So I'm just telling you, she's involved heavily. When I wouldn't talk to them because I didn't agree with this, they were messaging her, calling her 35 times a day. Why won't your mom talk? We're worried. We think something's going on. I mean, yeah, something was going on. I was talking to people, and they were telling me, like, this is a known thing that people are doing right now, and it just doesn't make sense at all. I mean, I would never, ever do that, point blank, period. And they know this because I told the guy who was sitting in our house the very thing when I stormed out the house and told him I wasn't interested in what he had to offer. And now when I saw this, was just like recently, very recently, when I saw this they bought the house on September 23rd for $46,000. That's ludicrous, because I turned down $500,000 offers, not because of the dollar amount, but because I didn't at that time even consider selling my mom's the property. So that's why I turned those down. But there's just no way I would go and take it $46,000 when I've had $500,000 offers, a lot of them. I mean, you can look up my property address and see what it is, the value. I would never do that, ma'am. And also, the purchase date of the house, they say September 23rd. Is that correct? Or
You'll have
what
to
did they
ask
say
them.
now? Or have they changed that?
It's like in November, I think.
Okay, well, all the legal paperwork that they sent to me asking me to leave says that they purchased this property on September 23rd, 2025. So I'm just curious about that whole thing there because I've got it right here. It's actually in your paperwork, I believe, that I scanned in. It was the Dunham letterhead, the first page of their letter. It says that property purchase September 23rd. And that was impossible because there was no estate executor or representative in place at that time that could justifiably do that. So the estate couldn't have been transferred during that time period.
Okay.
And you have to know that there's the many questions that I was asking them, he made it sound like I was crazy, like dumb, or, well, ma'am, I've told you a whole lot of times, so maybe if I have my attorney to tell you, you'll understand it in a more simple, way. Well, it's not that. It's that because what they were doing, it didn't make any sense. That's what it was. And it's totally not accurate. I wouldn't renege on a thing that I made a deal on. I would not do that. And I also wouldn't sell this house that we've had, like I said, for 55 years for $46,000. The property is worth, if we did the renovations on it, ma'am, it'd be $1 million. You know what I mean? And I know that, I don't know. It's just not. And then, by the way, I was told by Jeffrey that I would also have to reimburse Synergy for that $30,000 renovation. Why in the world would I do that if it's not my house? I mean, why would I pay $30,000 for someone else to renovate a house? I mean, that's ludicrous. Who would do that? They're taking back every single thing they say they gave. In the end, if you read their itemized statement, there's nothing given for this house. And it was never made as an offer for this house. And if they were going to do renovations, it would far exceed $30,000, just the kitchen alone. I mean, I don't know why they, where they come up with these numbers from, but no one even looked at the house now.
Okay. Is there anything else you want to add? Okay. Mr. Dunham, do you have any questions on cross-examination for Ms. Wiggins?
Oh.
Ms. Wiggins, at the time that, yes, Your Honor, I do. Ms. Wiggins, at the time that you signed the purchase agreement, the PA, which was dated September 23rd, was the mortgage current or behind?
It was behind. It was behind because I was not, well, let me tell you something though, but we weren't going to lose the house. You guys made me feel like I was, but I'm smarter than that. But Georgia, federal law states that the successor of interest has to be given the opportunity to go
Ms. Wiggins, stop just for a second. Yeah. What is say that again, Mr. Dunham?
Well, I'm going to object to all this other colloquy as non-responsive. I asked her if it was current or behind. She said behind.
Okay. So it was behind. What's your next question?
In fact, the mortgage was being listed for foreclosure, was it not?
It was being listed for foreclosure because the mortgage company did not realize that my mom and dad were dead. Okay. And that's why there had been no communication.
After the mortgage was listed for auction, Synergy contacted you and you reached agreement which resulted in Synergy paying off the mortgage. Is that correct?
Yes.
That's all I have.
They did pay off the mortgage. And I also offered to pay them back long ago, and Jeffrey said no.
Okay.
He wouldn't let me pay on that.
Do you have any other questions, Mr. Dunham?
No, Judge. I think we're good.
Okay.
Mm-hmm.
All right. All right. Anything else from either side?
I mean, I can close if you want me to close, but I think you've got it.
All right. Anything else you want to say, Ms. Wiggins?
I guess not. I mean, I'd like to, right, but this is in the same court again. Yeah, I mean, I feel like I should have legal representation, but I guess that's neither here nor there because they tricked me and made me think that this Brian Douglas guy was my attorney representing me on my behalf on probate when he was really, when I said this to Jeffrey, his exact words were, yeah, when I said, you didn't take me through probate to save my house. You took me through probate so you could take my house. And he said to me, his response, yeah, that's what Jeffrey said. Yeah. So he agreed that that's what he was doing.
That's what they all do. This is like going to a sleazy used car lot and then saying you sold me a crappy car with a high interest rate. Yeah, that's what they do. But you were desperate and you agreed to all of it. It sucks, but that's where you are.
It's really sickening.
Okay. All right, folks, after all the evidence I've listened to today, I do feel like there hasn't been anything, essentially I've been presented with 4 documents that show there was an agreement to sell the property on a certain basis and that the defendant has received funds as a result of that. There hasn't been any expert witnesses or anything to say that any of these documents are forged or anything along those lines. So I do feel that the plaintiff has met their burden today. So I am going to issue the writ of possession in the case today. That will be available 7 days from today's date, which is going to be...
They sure as hell have met their burden. It maybe isn't a good deal, but it's the deal, and they have the goods and the evidence, and that's that. As a matter of law, there's no two ways about this.
April 22nd, birthday.
The 22nd. All right.
All the news stations will be there.
Okay, that's going to be 11:59 p.m. on April 22nd for the writ. That is all they're seeking. So that will be the order of the court. You guys are free to log off. Thank you.
Thank you, Your Honor.
Thank you.
So now we go back to probate and sue the fuck out of them. That's what we do.
Say court to the Zoom.
The marathon streak continues with a grumpy.
Hi, sir. Can I please have your name?
Scott Carlisle, lady. And this is not a court hearing. This is a Zoom hearing. I have not put my hand on a Bible. I have not seen anybody put a hand on a Bible.
Right. We'll call case 228470 SM1. Mr. Leedy, you are here for arraignment purposes, and you're here with Mr. Jarboe, who is the defense attorney with the Michigan Indigent Defense Commission, here to assist you. Mr. Jarboe, did you have the opportunity to view the allegations on the bench warrant and the nature of the statement?
I can't understand a thing you're saying. All it does is echo in here.
I can speak up a little bit. Is this more helpful?
No, it isn't. It just echoes.
Right, is there an officer that's right outside that door?
Pardon?
Is there an officer outside the door who might be able to help us with communication?
There ain't nobody out here that I know of.
So I'm going to try and place you and Mr. Jarboe into a breakout room.
Your Honor, that's not necessary. We've already
Have
spoken.
you already met with him?
So what I would share with the court is that it appears that Mr. Leedy failed to appear while out on bond for a competency hearing on January 27th of 2025. I have reached out to his attorney, Mr. Conley, who has already been assigned this file, but I have not gotten any information.
That's Ali Khan. I know who he is. I fired him in the last court hearing, in previous court hearings.
So
he doesn't do a job.
Based
There's
upon
no investigations. There's no investigations, anything.
All right, Mr. Lee, I'm muting you so that we can get through the court hearing, okay? Mr. Jarboe, if you could please continue.
Thank you. Based upon my communication
It's a miracle. All of a sudden he can hear.
Today with Mr. Leedy, it would be my opinion that he will be found incompetent. I don't have the report, but that's my educated guess. He will not be cooperative or understand what's happening today. So I would simply ask that the court schedule the matter at its most convenient and earliest time possible when Mr. Conley is available. I would ask the court to reach out to Mr. Conley to see when he can appear with Mr. Leedy to complete the competency hearing, which appears to be what was supposed to have occurred back in January of 25. And I'll leave it to the court's discretion regarding bond. I have no comment on that other than I really have no comment. That would be helpful.
Okay. We lost Mr. Lee.
Oh, there you go. Is he gone?
Yeah, he got up and left. He was in
Okay.
a different room. No, yeah.
Your Honor, I would indicate as on the action in court that the notations from 2025 indicate once he was picked up on this bench warrant would be to reset the competency hearing ASAP or what's written. So I would certainly
Yes, we have
encourage the
reached-
court to reach out to Mr. Conley and get that scheduled.
I think so. Hi, there we go. Simmons. Hi, okay. Well, we gotta finish. Okay. Hi, I'm so sorry. We did not finish Mr. Leedy's court hearing because he walked out, but okay. Hi, it's Dana on 86. Mr. Leedy just walked out. Does he? Thanks. Bye.
I don't know if he comes back or not. I got this clip as we went. Only Zach knows. I don't know.
Hello.
Hi, sir.
Mr. Levy is not wanting to speak to you anymore, and he did not.
That's
He's
okay.
very rich.
Okay, that is okay.
You're out of
Mr.
luck.
Drivel, I will remand him pending that next court date then.
He just rage quit.
I would just encourage the court to encourage the court to set this as soon as humanly possible, but
Yes.
with due consideration for Mr. Connolly's schedule.
Oh, Paul, you and your reasonable.
We will
standards.
encourage that swift scheduling.
Thank you.
All right, thank you.
I think that's it for me.
All right, there you have it. I didn't intend for this to be a marathon. It just happened due to various circumstances, but it was good times. Lots of good stuff in there. I can take you out with the Beaver from the Thunderdome. I'm almost there. We might as well just cross the 3-hour mark and make it official.
Friday night. I'm in a mood. Definitely don't call me to bail you out, dude. I'm just not feeling it. I'm telling you straight. Oh, wait. Is this case great? I think I know this guy. He's back again. This is
So how can I prevent things like
friend. Your Honor, I apologize for how I fled the scene. I just had to get out of the Thunderdome, if you know what I mean. I was in a little pain my first time in the court, but I'm back with my complaint of a very special sort. There's an infestation, Judge. It's truly hard to bear. There's a critter in my trailer and it's living under there. Is it a mole? Is it a rat? He just doesn't know, but it's bigger than a cat. Mike says, is this the guy? The beaver mole guy. He was crazy the first time. Oh my, oh my. A beaver infestation is no laughing matter, but this whole dang story just gets madder and madder. The court sent an inspector to check the holes and poop, but he was hired by Mr. Weasel and I'm in a feedback loop. He's my next door neighbor, he's not insured at all. He owns another trailer park, he really has the gall. It's a major conflict of interest, it's totally absurd. He's the burglar investigating himself, take my word. Oh my God, Mike just can't breathe. A landlord inspector hired by Mr. Weasel. You won't believe it's a good thing I didn't start cocktailing before this one. The beaver mole guy is just way too much fun. The judge says, where's the escrow? The rent for November. He says, oh, I just forgot. I didn't remember, but I got it, Judge. Don't worry, the money is secure, but the inspector's report is clearly perjury for sure. I was not prepared for this denial of reality. I'm talking point number 17 specifically. Is it a mole? Is it a rat? He just doesn't know, but it's bigger than a cat. Mike says, is this the guy? The beaver mole guy. He was crazy the first time. Oh my, oh my. A beaver infestation is no laughing matter, but this whole dang story just gets madder and madder. The judge said, hold on, son. I'm getting quite confused. We were talking giant beavers, now I feel a bit abused. He says, my trailer's closest to the wood line and the lake. That's where the big beaver-like thing gave me a shake. But the skirting's done. So now I know the deal. The baseboards are ground zero. That's what's real. This is one of my favorite cases. I'll say it before it's over. I might have to make a song about this beaver-loving rover. So, y'all behave yourself. Stay out of trouble. Don't get hurt. And for the love of God, don't call me. I'm on alert. Just take a damn Uber and leave me all alone with Mr. Weasel and the beaver from the Thunderdome.